We're going to do some reminders of dates and times coming up in just a bit, but I do want to make sure we have everybody on the call first. We got about 10 more people to come on. So we will do that right before break, and we'll do some reminders again on Thursday. Definitely want to make sure everybody's on the same page. As one of you reminded me when we logged on this morning, we only have a week left. So 1 week from today, you guys are breathe. Always remember to breathe. All right, so Unit 19 is fair housing. And I mentioned the importance of fair housing last week, not just for your exam. Yes, you're going to have some questions on fair housing on your exam, but fair housing is also important for your career. You guys, this is just the beginning of your introduction, if you will, to fair housing. We got some more for you guys in post-licensing. And the other thing I have to say about fair housing is it pops up frequently in our continuing education classes. It'll pop up in your firm's training. So you will be exposed to fair housing pretty much for the rest of your career. It's so important that we keep revisiting these topics, especially as society changes, things change, and fair housing is trying to keep up. Let me go ahead and get this out here to begin with. Do I have everybody's attention? Fair housing is not here for you to agree with or disagree with. Your personal feelings and beliefs and thoughts do not matter. When it comes to fair housing, this is what it is. I may bump on some of your moral compasses in this unit, but again, you guys, it is what it is, because fair housing regulates how we deal with the consumer, whether they're the buyer, the seller, the landlord, or the tenant. Whenever you're a consumer involved, then we have to honor and follow fair housing. So Unit 19, we're going to talk about the Civil Rights Act of 1866 and how that evolved into what we know today as fair housing. We're going to list and define the protected classes. Who are the protected classes? We're going to talk about those a little bit. And then we're going to discuss the difference. Understand there's federal fair housing and then there's state fair housing. So most states have adopted their own policies. So we have to honor both. We're in the federal and we're in the state of North Carolina. So we're going to talk about both and how it's enforced if a consumer has a complaint, how they can proceed to do that. So let's start on page 476. Please note the word housing. When we talk about fair housing, we're talking about the residence, the dwelling. Fair housing is not about public spaces. Fair housing is not about commercial. Everybody see that? That word housing implies the residential, where we live. And let's understand the big picture of fair housing. Let's just take a few steps back and look at the overall picture. The big picture of fair housing says that everybody should have the right to live wherever they want, as long as it's within their financial means. So the big picture of fair housing says everybody should have the right to live wherever they want, as long as it's within their financial means. When it comes to complying with fair housing, anybody and everybody involved in the real estate transaction has to comply. So of course, you and I, the real estate brokers, apartment managers, property managers, lending agency, your lenders have protected classes in fair housing. We'll talk about those. Builders, developers, your real estate organizations. We've talked, for example, about the National Association of Realtors, the North Carolina Association of Realtors, and then your Board of Realtors, for example, the Winston-Salem, High Point, Greensboro Board of Realtors. So all have to comply with fair housing. Again, as I mentioned the other day, I can't think of a faster way for you to get yourself in trouble than to violate fair housing. Because now you're looking at dealing with the courts, you're looking at criminal, civil violations. Of course, the Real Estate Commission is going to weigh in. They may enforce disciplinary action. Good morning. So again, it's important. And understand, you guys, This is just the introduction. We're just easing in. So let's start with a little history lesson. Let's go back in time a little bit and see where this all started. It all started with the Civil Rights Act of 1866. Where are my history buffs? What was going on in 1866? And you can, yeah, I've seen your mouths move, your actions. The Civil War was ending. We were coming to a new place in our country, and we were recognizing all people. And one thing we got, the thing that we got from the Civil Rights Act of 1866, was that we could no longer discriminate on the basis of race and color. Now we're going to define the protected classes in just one second. So we will define race and we will define color. The Civil Rights Act of 1866 is one of the oldest acts that we have today. The Civil Rights Act of 1866 is still enforceable today. Y'all seen that year? 1866. That was a long time ago, yes? And it's still enforced today. One thing that makes the Civil Rights Act of 1866 unique is that it's not just about residential. The Civil Rights Act of 1866 applies to residential, commercial, business, employment, a pickup game of dodgeball, everything. The Civil Rights Act, we can never, ever discriminate on the basis of race and color. No exemptions allowed. So this is where it started, 1866. Now we're going to fast forward, 102 years? And in 1968, the Civil Rights Act of 1866 evolved. And in 1968 is where we adapted what we know as today is federal fair housing. So in addition to race and color that we've always had, in 1968, we picked up religion and national origin. Again, we'll define the classes in just one second. So in 1968, in addition to race and color, we added religion and national origin. Fast forward again to 1974. And in 1974, we added sex. Please look, before I forget, with me in your book on page 477. The bullet points up at the top. Do you see where it says sex? And then it says male or female gender. Does not protect against sexual orientation or gender identity. You guys see that? As of February 2021, gender identity and sexual orientation are now covered under sex. So as of February 2021, again, fair housing constantly evolves, as does our society. So today, sexual orientation and gender identity is under the category of sex and is a protected class. Fast forward again one more time to 1988. In 1988, we picked up handicap, disability conditions, and familial status. Again, defining the classes in just one second. 1988, y'all, that was not that long ago. And we just then picked up handicap, condition, disability, and familial status. I do think you guys may want to spend some time with the chart in the book on 477, because the first 1, 2, 3, 4 lines there tell you what act, what year brought in what protected class. And guys, I would not put it past them on your test to give you a question, something like the year is 1972. A woman applies for an apartment. She feels like she was denied because she's a female. In 1972, could she be denied because she was a female? Could she? Yeah, because sex wasn't a protected class in 1972. So in addition to knowing the protected classes, I do think you guys should know the years that they came into being. And that's why I think this chart on page 477 helps. The last entry there, the Equal Credit Opportunity Act of 1974, those are your lenders' protected classes. So the lenders have similar, we're similar, but they do have some protected classes that we don't, and vice versa. We're going to talk a little bit more about them. We introduced these to you back in our financing units, but we're going to talk a little bit more about the lender's protected classes in just a bit. Yeah, do you have a question? So we know when the protected classes came into play. So who are the protected classes? Well, there's a couple different methods we have to help you guys remember the protected classes. I like Fred's corn. Some instructors may use fresh corn. Fred's corn versus fresh corn, it's whether you use the D for disability or the H for handicap. So whichever one you prefer. So Fred's corn just helps us. It's a little mnemonic to help us remember the protected classes. Again, the chart on 477 helps us remember when they came to be and when. So let's talk about what these are. Familia status. Familia status is about the children. Children are protected class. In this country, anybody under the age of 18. By the way, this does include women with child. So pregnant women fall under this category too. I think we're going to talk more about familia status. We're going to get a little bit more involved. But I think familia status comes up more in the for lease transaction than the for sale transaction.
I had to buy that.
For lease, the landlord or the property manager may think that they don't want kids to live there because, you know, kids like destroy stuff and they color purple crayon on walls and they break stuff, right? They do things. We got a mute situation here. If you guys could check your keyboards. Sometimes there's a book laying on your keyboard. So make sure it does absolutely, familia status does absolutely come up in the for sale situation as well. Again, we're going to talk a little bit more about this. What we need to understand right now on this slide is that the children are a protected class. We cannot discriminate against children, familia status. The R in Fred's corn, or the first R, is race. This is a group of people that the individual was born into or has affiliated with their entire lives. The group of people that someone was born into or has affiliated with their entire lives. Equal rights for all is not a protected class. It's just there as a filler, so we could spell Fred's. So equal rights for all, again, just a filler. Disability or handicap condition. This is any physical or mental impairment that limits one or more of life's major activities. So those with handicap, disability are a protected class. Sex, an individual's gender. As we said, as of 2021, what was that, 2 years ago? Now under the category of sex is sexual orientation and gender identity, both protected under sex, under fair housing. Color is referring to the actual color of a person's skin. Opportunity for all is not a protected class, just a filler. So your vowels are fillers in Fred's corn. Religion is an individual's spiritual beliefs. And national origin is the country in which an individual is born or where their direct ancestors derive from. So where an individual hails from is their national origin. So here are your protected class. They're spelled out for you guys on pages 476 to 477. Again, getting a basic understanding of who the protected classes are. This is what we need to understand about the protected classes. Fair housing does not say, these are the protected classes, don't you say anything bad about them. Fair housing says, these are the protected classes, don't say anything at all. We cannot talk about the people. We can talk about the property all day long, but we cannot talk about the people. Fair housing says this is their law. You're going to have people to give you guys pushback. You're going to have people to try to argue with you in various situations. Fair housing says, look, this is our law. Put this on us. If the consumer doesn't like what you're telling them regarding fair housing, put it on us. I'm going to talk a little bit more about that. Understand this as well. Guys, right now, these are the only protected classes. So any other class is not protected, which, I mean, you know, you can discriminate away if you wanted to. For example, do you guys see political affiliation on this list? Political affiliation is not a protected class. Could you discriminate against political affiliation if you wanted to? Your moral compass may not allow you to, but according to fair housing, could you? Probably about 7 years ago, my husband sent me a house for sale in California, and the public remarks said, house for sale, Trump supporters not welcome. Did that person violate fair housing? No. Did that person maybe limit their pool of buyers? Yeah, because even, you know, non-Trump supporters may not want to work with that person. You guys with me? But as far as a fair housing violation goes, did they do anything wrong? Absolutely not, because political affiliation is not a protected class. What if you have an apartment to rent and you decide you don't want to rent to any daggone real estate agents because they don't have consistent income, they don't get paid monthly? Could you discriminate against a real estate agent? Could you discriminate against an occupation? Yes, because it's not a protected class. Everybody hear what I'm saying? These are the only protected classes according to fair housing. Now, again, I am probably bumping on some moral compasses right now because I understand a lot of you guys are going, gosh, I don't care what your political affiliation is. I'm still not going to discriminate. I don't care what your job is. I'm still not going to discriminate. And that's great. I think that's good. But what we need to focus on is what federal fair housing tells us the protected classes are. Make sense? So we're going to come back and revisit. I got more to say about familiar status and handicap. Good morning. So we're going to come back and revisit that in just 1 second. Equal opportunity in housing. The equal opportunity in housing, this is all developed by, enforced by, regulated by HUD. HUD is the Department of Housing and Urban Development. And one thing that equal opportunity in housing, fair housing provides us is a poster. There's a sample poster for you guys on page 478. HUD requires people, real estate firms, builders, developers, lenders, anybody dealing with the public as far as housing goes, are required to put this poster up per HUD to let the public know that we as a firm are not going to discriminate against the protected classes. Now, there's some words on that poster that we are getting ready to define, so please bear with me. As a matter of fact, HUD says failure to put this poster up where the public can see it, just failure to put the poster up in itself could be seen as a violation of fair housing. So when a consumer walks into the front door, they should see this poster and know that the firm is not going to discriminate against the protected classes. One thing I do want to point out, on page, like, for example, 479, Unit 19 does a really good job of giving us examples. So I do encourage you to look at the various examples, the figures. So we got on page 479, there's what's prohibited by the act, and then some examples. I got some other examples for you guys in the online learning system as well, just to help you wrap your brains around it. Any questions so far? Have I ever had or witnessed an issue? Unfortunately, I have. Unfortunately, it happens every day in real estate. Guys, as real estate agents, as brokers, as licensees, one of our biggest jobs is helping to educate the public. And this is one area that the public needs lots of educating. So we're going to encounter people that aren't familiar with the protected classes. We're going to learn in just a second that once somebody brings in a real estate agent, their discrimination isn't even allowed. We can't even discriminate through us because once they have an agent involved. So yes, we do encounter this regularly. And this is why it's so important that we understand so we can help educate the public. Bottom of page 479, it gives us some expanded definitions. So to expand on some of the definitions, again, housing is just referring to the dwelling. Housing is referring to the space designed for occupancy. Again, please note the word housing. I think this is a problem topic. This is not commercial. This is not public places. This is where you live. May it be something that you own or something that you're renting. As we said, familial status is children and pregnant women. Let's see, if you're a property manager, let's say you're a property manager and you have a large apartment building downtown somewhere, and it's like 15 stories tall. It's a big one. And you have somebody come in to apply for your vacant unit on the 12th floor. And that person that's applying has 3 young kids, all under the age of 5. Remember what we said at the beginning of this unit. The big picture of fair housing says anybody should have the right to live wherever they want, as long as it's within their financial means. So could you, as the property manager, deny that family their application for the apartment on the 12th floor because you're worried about the child's safety, the children's safety? Could you, as a property manager? No, if they meet the credit applications, if their financing matches up, then we can't deny it. We can express concern. You may want to run up there and make sure the balcony is reinforced really good. You guys with me? But even though I think it's what's in their best interest, it's not up to me. It's up to the people. As long as they can financially afford to live there, if that's the unit they want. Let's switch that over to a for sale situation. You will work with buyers that have kids that will ask you, are there kids in this neighborhood? Are there kids that live in this neighborhood? Again, you guys, fair housing says we can't discuss the people. Because the children are protected classes, can I answer that question? Can I say yes or no, there are kids in the neighborhood? So what can we talk about? Well, we talk about the property, the amenities, the things nearby. So maybe when you're asked, are there kids that live in this neighborhood? Maybe we start the conversation. You know, I understand you have children. Is there a certain school district you want your kids in? Are school districts the protected classes? No, so we can talk about school districts. There's a playground down the street. Can I talk about the playground down the street? Sure, because we're not talking about the people. So when they want to know why if kids live in this neighborhood or not, we can't answer that. But what we can do is try to have a conversation about the amenities, about the things. If you look at the amenities and the things in the neighborhood, it's going to tell you if it's a kid-friendly neighborhood. So we're not diverting the conversation. Fair housing says don't divert it, don't ignore it, don't, put your head in the sand and pretend like that didn't happen, pretend that they didn't ask. But instead, try to educate the consumer, try to educate the public. And besides, just because there's kids in the neighborhood, is there any guarantee they're going to want to play with your kid? There's no guarantees, right? So all we can do is talk about the kid-friendly features or not in that neighborhood. We cannot talk about the kids. Can we say kid-friendly or something of the sort? Careful of that verbiage, because now we're talking about kids. Right? So what do kids like? Kids like playgrounds. Kids like public pools, right? Parents like good schools. Everybody with me? Kind of have the conversation about What, is it awkward? Sure, it can be. Fair housing absolutely can be. But again, we are helping to educate the consumer. As far as handicap disability status, for lease, let's see. Okay, so we're going to talk about handicap disability right now. For the for lease situations, a landlord can't deny a tenant to make reasonable accommodations for their handicap and disability. So remember, the big picture of fair housing says anybody should have the right to live wherever they want. So if a tenant applies for to rent a home maybe, and they're in a wheelchair, the landlord has to allow them to put a ramp to the front door. If they want to lower the counters, the kitchen counters, the landlord has to allow. If they want to put safety bars in the shower, the landlord has to allow. In a for rent situation, the landlord cannot deny a tenant from making accommodations to the home to fit their handicap disability. Now, here's the deal. The landlord in residential generally doesn't have to pay for it. They can require the tenant to pay for those accommodations. There's funds available that the tenant can apply for, the handicap tenant can apply for. And the landlord can also require the tenant to put it back to its original condition at the end of the lease. So if you have a tenant that wants to put a ramp on the front porch, the landlord has to allow it. They have to allow it. But they cannot, they can require the tenant to take it down at the end of the lease. So the question is, what about people with disabilities? They need to move for obligation and one that is special for that in any other apartment. I mean, again, if the unit's available, then, the landlord can provide it to somebody with handicap disability conditions, and they have to allow them to make reasonable accommodations to adapt, because they're living there. So they need to be able to adapt to their living accommodations. I remember we said last week, for lease situations, a service dog, right now the only breed recognized is dogs. So a service dog is not a pet. So the landlord may charge a pet fee, but they cannot charge a pet fee for a service animal. That service animal is considered an extension of the person with the handicap or disability. Think of a service animal as no different as a cane or a walker. It is what they need to accommodate their disability handicap. Now, so we said last week too, if the service animal damages the property, then you can take whatever that amount is to repair it out of the security deposit. So you can use your security deposit, you just cannot charge a pet fee. There's an in practice in your book, page 480. The in practice on page 480 says that those that are in recovery or in rehab are considered a protected class under handicap disability. Current users are not, but those in rehab or disability are considered a protected class. Are properties such as apartments required to have handicap parking? So now we're talking about public accommodations with parking. Remember, public is under the American with Disabilities Act. And you guys shake your head yes or no. Do all employers have to abide by ADA? All of them? Every single one of them? I'm seeing head shake no. You are correct, because only those with 15 or more employees. So please hear me, you guys. Federal fair housing is about the dwelling. ADA is about the public accommodation. So this large apartment complex, if the employer has 15 or more employees, now they have to abide by both. The inside unit for the residents, the housing, and then public accommodations such as parking, clubhouses, etc. Is federal fair housing the same as equal opportunity housing? Equal opportunity housing comes from federal fair housing, yes. Yes, both regulated by HUD, both under that, all that same category. Because that's what federal fair housing is about. It's about equal opportunity for all when it comes to housing. There's another protected class under handicap disability. We talked about this way back in Unit 7, and we talked about things that are and are not material facts. And one thing that is not a material fact are stigmatized properties. And we said, you know, state law says you can hide behind material fact and say, I don't have to disclose this. I don't have to volunteer this information. But there was one exception to that rule. You guys remember that exception? One exception, stigmatized properties. I see mouths move. If you're ever asked, did anybody ever live in this home that had AIDS or HIV? Did anybody ever live in this home that had AIDS or HIV? Your answer is always, y'all hear my absolute word here? Your answer is always, federal fair housing prohibits me from answering that. Write that down. Federal fair housing prohibits. We know what the word prohibit means? Prohibits me from answering that, because those with AIDS and HIV are a protected class under the handicap disability. So whether you know or not, remember, we can't talk about the people. Your answer is always federal fair housing prohibits me from answering that. Question comes in, how would you even know? What if it's your best friend's house? What if it's somebody you know, a family member? I get asked all the time, have you ever been asked that? No, I have never been asked if somebody ever lived here with AIDS or HIV. But if I am ever asked that question, I know how to respond. And that's what we're doing here, you guys, is we're teaching you the parameters of your future career. Does this make sense? So maybe you'll never hear that question in practice. But if you do, you need to know how to respond. Your answer can't be, I don't know, let me find out, or yes or no. What is your answer always? Federal fair housing prohibits me from answering that. And then you stop the conversation. You've answered the question. So again, ADA, we mentioned it again on 481. We're going to do a nice side-by-side comparison because I do think this is a problem topic. Fair housing is about the dwelling. ADA is about the public accommodations. One picks up where the other one leaves off. So we're going to do a side-by-side comparison in just 1 second. All good acts have some exemptions. Fair housing is one of them. There's some exemptions to fair housing. We're on page 481. The sale or rental of a single family home is exempt. Dwelling is the residence, the housing where you live. So the sale or rental of a single family home is exempt. Someone that does not own more than 3 houses at a time. In fair housing, basically what we're saying is the for sale by owner is exempt. If you're an investor and you own 4 properties, are you exempt from fair housing? No, this is only a limited amount of ownership. Someone that does not own more than 3 homes at a time. Again, once you bring in the real estate agent, whether you're on that side of the transaction or you're assisting somebody on the other side, anytime an agent gets involved, discrimination is no longer allowed. And the other thing, the other exempt, well, not really, but the other thing that fair housing says is that discriminatory advertising is never, ever allowed. So while you do have some opportunities to discriminate, you can't advertise your discrimination. Remember my apartment for rent, but I didn't want real estate agents because they don't make consistent income, and I don't want those agents there hanging out telling me all about what to do and what not to do, so I'm just not going to rent to them. That's fine, that's a choice I can make, but guess what? I can't advertise that discrimination. I can't say real estate brokers need not apply. So while discrimination can, depending on who, not protected classes, but advertising discrimination is never allowed. Somebody with no felonies, criminal acts, that's not a protected class. You can't advertise it. Could you discriminate against somebody that had felonies or misdemeanors in their past? Could you deny housing to them? Sure, you just can't advertise it. Do we see ads all the time? I know where you guys are going. Y'all are going through Craigslist right now, aren't you? Do we see ads all the time? Does that make it okay? Does federal fair housing say, well, everybody does it in Craigslist, so it's all right? It's not a problem until it's a problem, and then it's a problem. So do we see? Absolutely. Does that make it okay? No. What happens when they get caught? Well, we're going to come to that in just a second. Other exemptions, if it's a rental and an owner-occupied 1 to 4 family dwelling, so you own a duplex and you live in one of the units, you can choose who you want to live in the other unit. Owner-occupied 1 to 4 dwelling. Again, you can't advertise that discrimination. But for example, I may choose in the other unit to not allow men to live there. I just want females. I can do that, assuming I don't have a real estate license. I can do that. I just can't advertise my discrimination. I can't say female applicants only. Religious organizations that own property that's just used for the members, they can choose to only allow their members to use the property that they own. For example, a church parsonage. The owners of the church could choose who and only allow the members of the church to utilize that parsonage. Same thing with private clubs. If there's a lodge or something up in the mountains, private clubs can allow that housing to only be used by its members. Becoming a member of the religious organization or private club shouldn't be discriminated against. But the private club and the religious organization can deny access to anyone who's not a member. And then there's an exemption for housing with older persons. It's not uncommon, for example, to find communities of 55 or older. These are allowed because they were designed this way. They were developed this way. They were put into place this way. I need you guys to understand something about this. The only exception to this is familial status, because we're exempting the children. That's what this is saying. Housing's for older persons. We're saying 55 or older only, which pretty much we're saying what? No kids allowed. Now, can the grandkids pack up their little backpacks and go visit grandma and grandpa for the weekend? Of course they can. Don't deny them of that. They can't live there. And as far as the exemptions, it's only familial status. These housings for older persons still can't deny race, color, religion, sex, national origin, or handicap. They cannot deny the other protected classes. So housing for older persons, 55 or older. So how is federal fair housing enforced? Well, we already said it was administered under HUD. Officially, its name is the Office of Fair Housing and Equal Opportunity. If somebody feels that they were discriminated against housing, the complainant has 1 year to file a report with the Office of Fair Housing and Equal Opportunity. They have 1 year to file the complaint. HUD will review the case. They will see if they believe there was a discriminatory act. If they do, then they will investigate further. And if they find that in fact discriminatory act has happened, they could pursue it in federal court. That court could offer civil and criminal penalties. And as a licensee, absolutely, the North Carolina Real Estate Commission will get involved as well. So as a licensee, take this a step further. Remember, the Real Estate Commission is not going to fine you. The Real Estate Commission is going to discipline your license. If you get fined, it's from the court. If you get your license disciplined, it's from the Real Estate Commission. If you get both, you know you messed up when they got you coming at both angles. Does that mean you can't show a person with 55 with grandkids living with grandma in a 55 plus community? I mean, generally speaking, yes, because those communities are for those that are 55 or older. I would look into that individual community to see if they allow. What we're talking about is 55 or older communities and fair housing. So what does each individual community, what are their rules and laws? Maybe they will. But the big picture says those of 55 or older are just designed for that, 55 or older. Y'all want to hear a heartbreaking story? This one always gets me. I had a pre-licensing student once share that grandma and grandpa were the guardians, and mom and dad were killed in a car accident. Grandma and grandpa had to move because we couldn't have the kids living in that 55 or older community. See, these are questions. This is why it's important to talk to an attorney as we're setting up wills and guardianships. Everybody with me? Because that might have been a question. Questions on fair housing, federal fair housing. So federal fair housing covers the entire country, right? Federal fair housing. We also have a state level. The state level of fair housing, North Carolina fair housing, came to be in 1983. Again, not that old. Here's the good news. North Carolina's protected classes are the same as federal law, federal fair housing. So Fred's Corn are the protected classes in North Carolina as well. Now, some states have more than fair housing, more protected classes than fair housing. So when we talk specifically about state fair housing, North Carolina state fair housing, Fred's Corn applies to both federal and state. The difference between state and federal for us then is a couple exemptions. And guys, please always remember, when we talk about a conflict of law, put real estate aside for a second. When we talk about a conflict of the law, the stricter of the two will prevail. So if you have a conflict between federal fair housing and state fair housing, which one's going to win? The stricter of the two. So one exemption, federal, as we said, allows for exemptions when the home is owned by someone that does not own more than 3 homes. So 3 or less homes. Federal fair housing says, well, they don't have to follow fair housing, but guess what? You come into North Carolina and the for sale by owner and the for rent by owner is not exempt. Which one is more strict? State or federal? Which one is more strict? State. So which one's going to prevail in this case? State fair housing. Federal allows for 3, not owned by 3 or more. State says FSBO and FRBO cannot discriminate. So if this were to wind up in a court of law, which rule is going to prevail? The state exemption. Another difference between the two, again, about the exemptions, the differences. As we said earlier, federal allows for a rental exemption if the owner lives in the unit. State says, well, we'll allow for a rental for rent by owner. FRBO is for rent by owner. FSBO is for sale by owner. State housing allows for rental exemption if the owner or their family member lives in one of the units. So again, back to that duplex, you own the duplex. Now you let your kid live there so they can go to school. State fair housing says you can choose who lives in the other unit. But again, which one is the stricter of the two? Which one is more restrictive? I'd say federal, because we only allow for exemption only if the owner lives there. So if this winds up in a court of law, in this case, the federal will prevail. State fair housing has an exemption that federal fair housing does not. In state fair housing, we have a law that exempts single-sex dormitories. So think about all of our dorm rooms, our college dorm rooms, our military barracks. In North Carolina, those are exempt. It's not uncommon to have a single-sex dorm on a college campus. You might have a what do they call it? Co-ed dorm. I remember my dorm, my first year of college, we were layered. It was like girls, boys, girls, boys. We were staggered all in the same building. Daddy didn't like that, but you know, it was allowed and it could get through with state fair housing. So again, same protected classes, just a couple different exemptions from federal and state. Another big difference is who enforces state fair housing. So state fair housing is enforced by the North Carolina Human Relations Commission. So federal is followed by HUD. State is enforced by the Human Relations Commission. Once again, the complainant has up to 1 year to file a complaint if they feel that they were discriminated against. If the complaint is filed on the state level, it more than likely is going to get pushed up to the federal level. If a complaint is filed in the federal level, it's more than likely to get pushed down to the state level. And remember, if you're a licensee, you're probably going to get the real estate commission involved too. So 1 year to file the complaint. Questions? Okay. I know we're just a minute or two early, but let's go ahead and take our break. When we come back, we're going to talk about some more things with fair housing. And again, I want to show you guys where I have resources for you guys as well. So let's take 10. Where is it? There it is. back. We are turning our cameras on. I'm going to take attendance, make sure I can see you. All right. So we've broken down federal, we've broken down state. So now let's talk about just some fair housing things. And over on page 484, we need to define some words. 484 is prohibited practices. Prohibited meaning what? Practices that are not allowed. So the first prohibited practice we have is called block busting. You may also hear block busting referred to as panic peddling. Please write this down. Block busting is about owners. May that be for sale or may that be for rent. Block busting is about owners. Block busting is the act of encouraging people to sell or rent their home by claiming the presence of a protected class in the neighborhood. So block busting is the act of encouraging people to sell or rent their home because of the presence of a protected class in the area. We cannot encourage, no matter how subtle it may seem, we cannot encourage somebody to sell or rent because of the presence of a protected class. Block busting is about the owners. Another prohibited act then is called steering. Steering, also known as channeling, is about buyers and tenants. Please write that down. Steering is about buyers and tenants. Steering says we can't drive buyers or tenants into or away from an area because of the presence of a protected class. We cannot encourage people to buy or rent here because of the presence or absence of a protected class. Block busting is about the owners. Steering is about buyers and tenants. As we said earlier, no discriminatory language ever in advertising. It's not allowed. Once you're caught, it's a problem. So we can never advertise our discrimination. Redlining is a lender's prohibited act. Can I please give examples? So you can't call a seller and say, they just built a Methodist church down the street, so there's going to be a lot of Methodists moving in the neighborhood. Why don't you go ahead and sell to get ahead of those Methodists? That's block busting. You're encouraging them to sell or rent. Same thing with steering. Hey, you're Methodist? They're building a Methodist church in this neighborhood. Why don't you live here? We can't direct people into or out of a neighborhood because of the protected classes. Remember, it's all about the amenities. It's all about the location. So redlining is a lender act, a lender practice. Redlining is about the lender. It blows my mind that this used to exist. Today, it's a prohibited act. Once upon a time ago, it was allowed. What redlining did, the lender, the mortgage company, would put a map of the city on the wall. And then they would take their red marker and they would actually walk up to the map and say, we're not going to originate loans here, here, or here. They actually circled places on the map and said, we're not going to originate loans in these areas. The idea of redlining is that we're not approving or denying loan application based on the people. It was being denied based on the location. And today, that is not allowed. As long as the people qualify, the person qualifies, the person's eligible for the loan, they should not be denied housing because of the location. Now, remember, we did talk about in financing that not all homes, not all properties are going to get approved for FHA or VA. So there's certain, appraisal conditions that they have to meet. So you can deny a loan based on the conditions of the property. You can deny a loan based on the person. Their debt to income ratio doesn't work out. But you cannot deny a loan because of the neighborhood or the community that it's in. Turn with me to page 486, back to advertising. Again, just the examples and the 4 practices and the things in Unit 19 are really good, just to help us better understand. And remember I said at the beginning of this unit that, society changes, so does fair housing. So if you guys look on page 486, under the category of race, color, national origin, you see where it says permitted master bedroom? Everybody see that master bedroom? Right now, as we speak, MLSs across the state are doing away with that verbiage. Master bedroom can have a negative connotation. It's being replaced with with owner suite, primary bedroom. I know, for example, Triad MLS has done away with that verbiage in their system. So things change, and that's another reason why it's so important that we stay on top of fair housing, that we have these continued reminders. This is why it pops up in CE. This is why it's going to pop up in your firm's training, because things change as our society changes, so does the verbiage that we can use. HUD has came up with a list of prohibited words that you can't use in advertising. And I got my hands on that list. It might have been 10, 12 years ago. And I tell you, 12 years ago, that list was like 26 pages long of words that you can't use. Now, you guys aren't expected to look, I'm sure it's more now, but you're not expected. But let me tell you what's happening. The first of last year, 2022, for example, the Triad MLS implemented a software in its program. So if you're typing in remarks, if you're putting in public remarks and you hit one of these prohibited words, it's going to give you a warning. Now it's going to say, don't use that word, but it's saying, make sure you're using that word appropriately. So for example, when they implemented this in January 2022, is that last year? January 2022. And I do data entry for my firm. And we work a lot with builders, new construction. And I was putting a listing in, and in the remarks, we were describing the white kitchen cabinets. And MLS flagged it. They didn't tell me I couldn't use it, but they just flagged the word white. That is one of those words that it identifies. And it didn't say you couldn't use it. It just said, caution, make sure you're proceeding appropriately. So because of softwares like this across the country, we no longer have to have that 26-page, document, or however many pages it is these days, because softwares allow the MLSs. And again, it never once said I couldn't use it. It just said, whoa, this is a word. You need to make sure you're using it appropriately. So just know that it's always changing. What's here today may be gone tomorrow. Vice versa. I would argue some of these permitted. Walk to shopping, I think that has a limitation in handicap disability. Family room, I don't know how that's not bumping off familiar status. So, just when we do our advertising, when we do our MLSs, we just need to make sure that we're proficient, we need to make sure that we're acting in accordance to fair housing. When we get into license law and commission rule in just a minute, we're going to talk a little bit more about the BIC. And one thing that we're going to learn is that the broker in charge is responsible for all of the advertisement that comes out of the firms. May you be a provisional broker or a full broker, your BIC is responsible for that advertising. So hopefully your firm has a policy in place where before you submit something, the BIC can review it. And one of the things that they're looking for is any violation of fair housing. But again, the software has really helped. So we don't have to have that list anymore. We don't have to know that list. So we're going to talk more about the BIC. What else is there? Responsibility with advertising. Again, when we get into license law and commission rule. Except for USDA loans, that's right. And again, what we're saying is you can't live here. We're just saying the loans only apply for rural areas, right? So even not in the neighborhood. I think the practice of redlining was done more in urban settings, urban areas than rural. Also in North Carolina, there's some protection from tenants against sexual harassment by their landlord. Sexual harassment, just any unsolicited request or demand for sexual act or sexual behavior. The landlord can't try to coerce the tenant into exchange or reduce rent for a sexual activity. North Carolina further breaks down. They say there's different forms, there's different versions of sexual harassment. Verbal is jokes or maybe suggestive comments. Nonverbal could be whistling or obscene gestures. And then, of course, physical is inappropriate touching or brushing or fondling. So tenants are protected in North Carolina. If they feel violated, then they should contact their attorney. So let's bring this home. What does this whole unit mean for us as soon to be real estate agents? Well, this is important. Fair housing says we can be found guilty of discrimination even if there was no intent. If a consumer feels that we discriminated against them, then we could be found guilty of that discrimination. You didn't mean to, but you made somebody feel like you were discriminating against them. Let's say, for example, I'm doing an open house on Sunday. And I got people coming in my open house, groups at a time. And I have my open house registry, and I have a plate of fresh baked cookies and lemonade in the kitchen. And people walk in the front door and I say, stop by the kitchen, sign my registry and get a cookie and some lemonade, right? That's how I greet people. That's how I get people in. And that's how I get people to sign my open house registry. But let's say a couple or a group comes in and I'm busy doing something else. Maybe I'm talking to somebody and I don't get a chance to say, sign my registry and have a cookie. I just say, hi, welcome, and have them come in. And then the next group comes in, I say registry and cookie. And they hear me say that to the group after them, the group after them, and the group after them. Could they feel discriminated? Because I told everybody else to sign my registry and have a cookie. Did I mean to? No, but did I make them feel discriminated? And that's what fair housing says. I didn't mean to, but it still happened. I made them feel that for whatever reason, they were not welcome to sign my registry and have a cookie. Another big picture of fair housing, I think, helps us wrap our brains around all this. What we do for one, we do for all. So if you ask one person to sign your registry and have a cookie, you need to tell everybody to sign your registry and have a cookie. If you're going into property management and you require one tenant to file a criminal background report as part of their application, then you have to require all possible tenants to file that criminal background report. Everybody with me? Once you set up your policy, what you do for one, you have to do for all. And that's one big way that we can prevent making anybody feel discriminated. Again, whether you meant to or not, it's not about you. Real estate is not about you. How did you make that other person, that consumer, feel? So as I mentioned, the guidelines, HUD tells us words to proceed with caution. Thank you for the new software program, at least in the Triad MLS. I'm sure some of the other bigger ones, Raleigh, Charlotte, I'm sure they have it as well. I can't speak for the others. If not here, probably coming soon. Just to make sure that we're properly using the words in our advertising. All of you said when we started this conversation that you see discriminatory language in advertising all the time. I guess my question to you is it in the housing? And if so, just because somebody else is doing it, does that make that okay? No, what's fair housing say? And that's who we need to follow. Don't keep up with the Joneses on this. Just because your fellow agent is doing it one way, does that make it okay? No, we care about fair housing. Also for us with fair housing, National Association of Realtors, NAR is the National Association of Realtors. And they suggest that firms put a sign up saying that it's the company policy not to discriminate, that equal opportunity housing poster would suffice NAR. And remember in Unit 8, we introduced you to the musts of our agency agreements. They must be in writing. They must have the broker's license number. They must be signed by all parties. And the fourth must, all of our agency agreements must contain that non-discriminatory language. We'll look at that again in just 1 second. Agency agreements include our listing agreement, our buyer's agency agreement, and our property management agreement. So all of our agency agreements have this non-discriminatory clause. Questions? So let's do a nice side-by-side comparison here. We talked about ADA, Americans with Disability. Now we're talking about federal fair housing. And this is the distinction, and this is so important. ADA covers public accommodations. Federal fair housing covers the dwelling. One picks up where the other leaves off. So if you are a landlord with single family homes to rent, all you have is single family homes. Are you bumping into ADA? Are you bumping into public spaces? No, you just have a house on a yard. What if you're a property manager with a large apartment complex? Not only are you dealing with housing, the apartment units themselves, but now you're dealing with a parking lot, maybe a pool, a clubhouse. Do you have to abide by ADA? Well, the answer is it depends. ADA is only there for employers with 15 or more employees. Could you abide by ADA? Sure, but you're only required to with 15 or more employees. I had a young lady in pre-licensing once, and she worked for a large apartment complex. I think she told us once there were like 150 apartments in this place. And the poor thing came in frazzled. This was a night class. And the poor thing came in frazzled every once in a while, particularly around the first of the month, because now she's collecting rent from all 150 of those tenants. And she shared with us, they were an employer with 15 or more employees. It was a large apartment. They had a pool and a clubhouse and parking lot, a playground, and all these public accommodations. And she said, have you guys ever heard of like secret shoppers going into the restaurant? Fair housing has been known to send secret shoppers to these large apartment complexes. They'll send them in and, make them act like tenants interested in applying to rent a unit. They'll have them call. She said they had these regularly. And if you were on the phone and you said or did something that could have been a concern, they'd slap you on the wrist, maybe make you take some training, get some more education. But if it was a repeat offender or repeat violation, then they may launch an investigation on the actions. So those going into property management, particularly those going into a large rental, please don't, this is just residential. If it's a large commercial, we're not living there. There are public places, but it depends on if there's 15 or more employees. Also, back at the beginning of this unit, we reminded you of the Equal Credit Opportunity Act. Remember, this is for lenders. So the lenders protected classes are similar, but a little different. The lenders protected classes are race, color, religion, national origin, sex. You'll note familial status is not a protected class under lenders. Why? Because the applicant for a mortgage loan has to at least be 18 years old. So lenders don't have a familial status. Lenders do have a protected class of age. Again, assuming the applicant is 18 years old. What we're saying here, if you have a 90-year-old apply for a 30-year loan, you can do that math, 90 years old applying for a 30-year loan, they cannot be denied of that loan because of their age. Lenders also have a protected class of marital status. You cannot be denied a mortgage loan because you're married, divorced, separated, single, etc. And then also protected class for the lenders is recipients of public housing. So having an understanding of what's protected both under the real estate agent and of the lender. And again, I direct you back to that chart on page 477. I like the chart. I think it helps put these classes in order and helps us remember who's protected by whom. The rest of Unit 19 talks about ethics, particularly the Code of Ethics. When you subscribe to the National Association of Realtors, you become a realtor. You can't call yourself a realtor until you join NAR. You can't join NAR until you join your firm. You can't join your firm until you get your real estate license. So remember those goals. But once you join an NAR, you become a realtor. If your firm requires it, some do, some don't. But if your firm requires it, you join NAR and become a realtor, you're held to a higher standard. That's what makes realtors different than brokers. Realtors are held to a higher standard because in addition to license, law, and commission rule from the Real Estate Commission, we also have a code of ethics. And that code of ethics gives us our written systems for conducting ourselves ethically in the real estate transaction. You'll learn all about the code of ethics, the 16 articles of the Code of Ethics. That'll be part of your new agent orientation when you join the local board of realtors. So you'll learn those 16 codes. Also, another one of these topics that pops up often. As a matter of fact, realtors are required to do Code of Ethics training every 3 years. The good news is it can count towards your CE credit, your continuing education. We're going to talk about continuing education when we get into license law and commission rule. It used to be we had to do code of ethics every 4 years. Then in 2017, they said that's too long. We need to remind people to be ethical more often. So in 2017, they required code of ethics every 2 years. And then about 2020, they said that's too much. So what's the Goldilocks? Today we're at 3 years. So as of a couple years ago, code of ethics is required every 3 years. Part of the reasons to require code of ethics periodically, again, you guys, the rules are tricky. It does touch on fair housing and the code of ethics. And as more and more complaints are filed, more and more reports are filed, National Association of Realtors is just making sure that we are conducting ourselves ethically. And in order to do that, then we need to be reminded of what those standards are. So a question comes in about where does Airbnb and Furbo apply or fall under the responsibility of us? Remember, they're a rental. It's a rental. And we talked about particularly estate for years. So if you have a for rent, a vacation rental by owner, if it's a week to week, Saturday to Saturday, you have an estate for years. You have an estate, how's the real estate agent involved? We got to follow the standards, follow the Unit 19. Same thing with Airbnb. If a real estate agent's not involved, as long as they're not advertising their discrimination, they can choose who rents their homes and who doesn't. Once you get an agent involved, discrimination is never, ever allowed. And that gets us through Unit 19. Again, those key terms. For this unit, I like the key point review. In addition to reading the unit and seeing the examples and the end practices, I think those help bring it home for us. But the key point review is a really nice summary. And then, of course, your student quiz on page 494. So we're going to go on the online learning system. In just a second, I'm going to point some things out to you guys, because I do have some other good resources for you. Again, it's all about helping you wrap your brain around it. We are going to be the front lines. You guys are going to be the front lines when communicating, when dealing with the public. I was asked earlier if I ever experienced. Of course I have. I had a coworker once, went on a listing appointment, and the gentleman in the listing appointment said, I'm not going to sell my house to fill in the blank of the protected class. And the agent said, why the heck does that matter? If they can get the loan, if they have the money, why do you care what they look like or what their religious beliefs are? And the guy was adamant. He was like, no, I'm not going to do it. I'm not going to do it. Not going to do it. Sometimes, you guys, we try to educate, we'll try to put literature in their hands, we'll try to have a conversation. But sometimes if you have somebody stubborn and hard-headed, it might be in your best interest to walk away from that listing. Thank them for their time. Do you want to work with that person? I mean, do you? Now you go through this entire listing and marketing process and an offer comes in and they decide not to accept it. It blows my mind how many buyers and sellers have shared with me over the years that they have Googled the other person in the contract. And they tell me after the fact, of course. And I don't know why. Like, why does that matter? Seriously, I'm asking, why does that matter? As far as the sellers are concerned, they really should only see one color, shouldn't they? That's the color green. If they got the money, if they can get the money, as far as buyers go. But yes, unfortunately, you do have people out there in the world that may try to tell you who's going to make an offer, may try to tell you who can show their home, may tell you whose homes they want to see. That's dealing with the public, you guys. So a big part of this is helping us educate the public. And if they don't want to be educated, again, you may need to make the decision if you want to work with that person or not. I'm not telling you how you should answer that. But if there's violations, you know, your license could be on the line here. So I guess my question to you is it worth it? And that's obviously a question I cannot answer for you guys. As long as we're doing what we're supposed to be doing and we're helping to educate the public, that's what Fair Housing asks. That's what the Real Estate Commission asks. So let's go out to the online learning system. A couple things I want to look at with you guys. We'll come back to that in just a second. But I want to do this first because I always forget to do it. So let's go back to our exclusive right to sell listing agreement. We're going to go back in time just for 1 second and look at one of our agency agreements. This is just the first one I came across. And one of the musts of our agency agreements is that it has the non-discrimination clause. And you can see, I mean, it's highlighted pink just for you guys. If it weren't highlighted pink, it's all caps and in bold. And this is telling the consumers that the agent nor the firm shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, realtors have an ethical duty to conduct such activities without respect to sexual orientation or gender identity of any such party or prospective party. Again, Fair Housing adopted that in 2022. So fair housing is now covered under, sexual orientation and gender identity is covered under all fair housing now, not just specifically to realtors. I'm still waiting on them to update this form. I don't know why they haven't done it yet. The forms committee never calls me and asks me my opinion. I wish they would one time, but they haven't yet. So I think it's just a matter of updating the form, but this rule, this has changed. So that's one of the musts of our agency agreements, things that are required in our agency agreements. Isn't that something? The things we worry about. Unit 19 has some good stuff for you guys. And one of my favorite things in Unit 19 is the Q&A brochure on fair housing from the National Association of Realtors. This is, no, I'm sorry, from the North Carolina Real Estate Commission, not NAR. This is from NCREC. And this is straight from the horse's mouth. Remember, there's Q&A brochures scattered all throughout your online learning system. I do hope you're looking at them. I think they're helpful in helping us better grasp this information. All of these Q&A brochures are written to the consumer. So you're talking to the public. Now, I provide it here for you guys to help you wrap your brains around them. I do encourage you to go through this brochure because it's another way of hearing what we just heard, another way of seeing what we just saw. The commission also has these available for us as agents to use. So when you're working with consumers, I'm just introducing you guys to some of the Q&A brochures that are available to us. There's a whole bunch. And it's safe to say when you're working with sellers, buyers, tenants, landlords, if you run into an issue, for example, or you just want to introduce them to a topic, we have these Q&A brochures available that we can put in their hand. So back to the stubborn seller that doesn't believe what I know that I'm talking about at fair housing because he or she doesn't want to sell to a member of the protected class. Can I help educate this stubborn seller by putting some literature in their hand? Can I provide them with this brochure? Now it's not just coming from me, it's coming from other sources. So use these Q&A brochures that are scattered in the system to help get you through the tests. But when you get in the real world, know that you have these available to help you educate the consumers, get them that information as well. So this is here for you guys. When you get into post-licensing, we'll spend a little bit more time. We'll show you where you can find these brochures. If you're eager, you can go to ncrec.gov. Yep, you can go to ncrec.gov. It's under publications. So you click on the publications tab, And one of the drop down is publications. Again, keep it simple for now. We're just introducing you these topics. So if it's related to something that we're talking about in class, I've already got it here. Once you get your license, if you want to go peruse, you're welcome to. So I encourage you guys to look at this. This will help you wrap your brain around fair housing. A couple other things I have in here for you guys is case studies. So these are case studies, and here's like a situation, and then it tells you A, B, C, or D. How are you going to respond? So I have various case studies here, and then the explanation of the answer is a separate PDF. So case study 1, this is what's up, and then this is the correct answer. I think, again, studying those scenarios, studying these case studies help us better understand. You may think you understand fair housing, but I encourage you to spend time with these case studies. Now, if you're thinking to yourself, it looks like Jill would copy this right out of a book, you would be right. And specifically, the book that I copied it out of, can you guys see this? I think it's backwards, but is the North Carolina Real Estate Manual. This is the guide of the Real Estate Commission. So the commission produces a manual, and there's a whole chapter, chapter 18, on fair housing, which is right where I got these case studies. By the way, when you guys get to post licensing, this manual will also serve as your textbook. So you get a whole new book in post licensing. Y'all want the good news? One book applies to all 3 post licensing. So we don't have to get 3 different books. We're just going to get one of these. You'll meet the manual when you come to post licensing. They just released a new one. I can't wait to get my hands on it. They updated. I don't know what yet, but I know it's purple. So that's pretty exciting this year. There's that. They gave us a cool color. The other thing I have for you guys in here, I mentioned earlier that fair housing pops up in continuing education every once in a while. The last time it popped up in CE was the 2020-2021 year. So this is straight from CE. I put the whole dang chapter in here for you guys to peruse. I don't think you should read this whole thing. I think that's more than what you need for your test. But I do have it in here for you guys to peruse, look at the highlights, look at the for examples. And again, there's more case studies. So there's for discussion. Betty hires Ray, da 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 da. Fast forward to the end of this chapter for the results of the discussion questions. Is Ray correct? Why or why not? So you can find that at the end. So what we're doing in Unit 19 in the online learning system is giving you real life examples, real life scenarios to help you wrap your brain around this fair housing. Questions? Well, I have you guys while we're here, just a couple reminders. Your cram course is this Saturday. Remember, we changed the time. The new time is 12 to 4. Jane's going to be with you guys on Saturday starting at 12. Lane will email you Jane's Zoom link on Friday. Check your spam. Be on the lookout for the email from Lane if you plan to attend. Check your spam because sometimes Lane winds up in your spam for some reason. She will probably do that Friday morning, early afternoon. So if you guys haven't heard from Lane Friday afternoon or evening, please reach out to one of us and we'll make sure that you get the link. Please do not wait until 11:55 on Saturday and say, I need the link. Okay, so be on the lookout. And if you don't get it by Friday evening or so, just reach out to either one of us and we'll give you the link. Also, the other reminder, your exam is 1 week from today, May 23rd. It's online. We're going to log on to Zoom like we always do. We will talk about rules and expectations on Thursday. Your exam, you're going to log on at 9:15. So just a reminder of some upcoming dates and times. Your retake is the 25th. To be eligible for the retake, you have to make at least a 50% on the final exam on May 23rd. So please make sure you have all this in your calendar. The other couple of reminders I have is we're getting closer and closer and closer to time. What I just said, yep, 75 is passing. 1 week from today is your exam. So what do you do to prepare for that? Still under the Julie folder, we have our end of class exam review. Anybody get a chance to look at that this weekend? So several of you. For the rest of you, want to know what's going to be on the test next week? Ta-da! So I encourage you to look over the end of class exam review. There are 112 questions. We're going to talk about it on Thursday. I promise you, I will answer all questions to the end of class exam on Thursday. Every single one of them, I promise. Also remember, you guys, there's 100% materials. So there's 100% exams. Here's another class marker exam. You can take this one as many times as you want. There's no limit. I know a couple of you did it this weekend. So you can do it again and again and again. Money talks. No, I'm just kidding. And then there's also a couple flat. So there's some PDF exams, of course, with the answer choices. There's practice final, there's a national section and a state section. With these flat PDFs, and even with this one will time you. But with these flat PDFs, I encourage you guys to set a timer, set a clock. Because if you haven't been practicing working with a clock, I need you to start now. I don't want anybody to run out of time. So however many questions this is, I would say about 2 minutes per question, and set the timer on your clock to make sure that you're getting through all these exams. And then there's also another 100% on page 819 of your book. So you got 1, 2, 3, you got 4 here in the online learning system. I'm in the 100% material. And then you got another one in your book on page 819. And you have the exam review that helps you hone in specifically on what you're going to be tested on. And that exam review does apply to the retake as well. So if you're preparing for the retake, you can use that exam review for that as well. Give you guys enough to do for the next week? We're here. I know before we logged on this morning, we were talking about it. So hard to believe, but we're here already. Any questions or comments about the cram course, not about the test, but any questions about the cram course, the 100% review, the exam review? Well, you guys are thinking, I need to stop sharing just for 1 second, so bear with me. I'm gonna skip around just a bit in the material. So we're gonna skip 18 and 16 for now. We'll come back and pick it up. I'd rather use our time on testable material, such as license law and commission rule. 16 and 18 are those units that, oh, where are you guys? Let me come back and get you. There you are. 16 and 18 are those units that you may get a test question. You will get test questions in license law and commission rule. So remember our relink book? This is the book that says, yay, I passed Julie's test. Now what do I do? How do I apply and background check and all that? When you guys are getting ready for the state exam, I want you to pay attention to pages 16 and 17 of this relink book that's under the welcome section. And 16 and 17 gives you the breakdown of how many questions you can expect to see on your state exam. And when I say you can only expect a question or two, maybe a question or two from these units, This is unit 1. This is unit 13. This is 16. And this is 18. So from those 4 units, you can expect to see 3 whole questions. So this is why we're going to skip 16 and 18 for now. I will pick them up. We'll get to that tomorrow. Question comes in, can you use a flashcard with the formulas? No. You start with blank scratch paper. Both my exam and the end of class exam. Everybody go with my train of thought? I'd rather spend more time on license law and commission rule than unit 16. License law and commission rule is down here at the bottom. Now you're looking at 10 questions. So this is where we're going to focus the rest of our energy. The license law and commission rule, where we're starting. The online learning system, license law and commission rule. We're going to start talking about the comments. I do hope you guys got a chance to look over this. This is the big chunk of your state exam, your state section, excuse me, the state section of your exam. This isn't all of your state section, but this is a big chunk. So I do encourage you to read the comments because it's all filled with testable material. And that's what we're going to talk about in just a second. In addition to the comments, when we get done with the comments, there's some other license law and commission rule not mentioned in the comments, but we're going to go back and pick it up. So I haven't asked you guys to read all of license law and commission rule. I just asked you to read the comments. So we need to go back and pick up a few other things. And then any other thing that says in North Carolina is a good candidate for the state section of your exam. So if you just open a random page of your textbook, I just opened up page 446. Random page. You can probably open any page and see what I'm seeing. But specifically on 446, in the left-hand margin, do you see where it says in North Carolina? When you see in North Carolina in the left-hand margin in your book, that could be a good candidate for your state-specific section. So we're going to start with the comments. We've been working through, obviously, the whole book. This is our last big section. Yes and yes, Caitlin. Yes to both. Is everybody good? Know what page we're on? What page I'm on, at least? Why I do what I do? You can help me understand. No, I'm just kidding. There's methods behind my madness, I promise. You don't have to remember all the rules. I did not ask you guys to read the entire license law and commission rule. What I asked you guys to read was what we're looking at right here is the comments. The commission thinks you should read all the license law and commission rule, but this isn't my first class. So if I could get you guys to read the comments, I think you'll be off to a good start for your exams. And that's what we're going to go through. Other questions, comments, concerns? Yes, Tuesday is our final exam, May 23rd. We're going to say goodbye for now because I will see you guys again in post licensing. How's that? Let that be your carrot. But guys, please remember not, I get so worried sometimes you guys put your cart in front of your horse. Before you can come to post licensing, you have to pass your state exam. Before you pass your state exam, you have to pass the end of class exam. Everybody with me? So make sure you're not getting ahead of yourself. You still got to get through this process. We did closings. That was unit 21. Is that what you're asking me? Unit 21 is closing the real estate transaction. Okay. Again, I know I'm just a few minutes before break, but let's go ahead and take break. When we come back, we're going to jump right into license law and commission rule. All right. And we're back. Welcome back. I had a question coming over break. If you don't pass the class exam, do you have to retake the course? Please remember your steps, you guys. You can't apply to take your state exam until you have a certificate of completion from a pre-licensing school. So you have to pass a pre-licensing class before you can go on to your state exam. So if you don't pass next week, you have to retake the class. It's the steps. Welcome back. Okay, so let me take attendance. And we are getting into our last major testable topic, which is license law and commission rule, probably often referred to affectionately as LL&CR. License law, LL, and commission rule, CR. I don't have page numbers on this PowerPoint because we are going through the comments. So we can, follow along with those comments. And then once we get done with the comments, like I said, we need to go back and pick up a few law and rule that we didn't get before. So here's our state specific stuff. The whole section here is discuss our license law, LL, and commission rule, CR. So let's start with our license categories. In North Carolina, we are all brokers. Other states may have sales associates become brokers. North Carolina is known as being one of the trickier states in this country to get your license in. How does that make you feel? And by the way, the Real Estate Commission is quite proud of that fact, so you're not going to change their mind. But here's the deal. Think of being a broker as getting a master's degree in real estate. Once you're a broker, you've achieved that master's degree. Other states use a sales associate, so it's like your associate's degree, and then you have to go back and get your master. North Carolina, we skip that associate stuff and we go straight to the masters. We go straight to the brokers. Also remember too, that being a broker does not make you a realtor. Getting your real estate license makes you a broker. Once you're a broker, then you can join the National Association of Realtors to become a broker and a realtor. So we're all brokers here in North Carolina. We do have different categories. So our first category is soon to be you guys. Is this your carrot? You want to be a provisional broker? Soon to be you guys. I call you guys my brokers with training wheels. How do you become a provisional broker? Well, you got to pass a pre-licensing class. You have to pass your state exam. You got to pass both classes or both tests. Once you pass your state exam, you become a provisional broker on inactive status. We're going to talk about the different statuses in this section. We're getting there. Just on what you know right now, do you think somebody on inactive status can practice real estate? Can you get paid commission? Can you do anything involved in real estate whatsoever? No. So basically what we're saying is, congratulations, you passed your state exam. Here's an inactive license that you can't do anything with. Good job. As a provisional broker, how do you activate your license? You have to affiliate with a firm. As a provisional broker, you have to be under the supervision of a broker in charge, BIC, broker in charge. How you drop the provisional status is by successfully completing the 90 hours of post-licensing. Now, we've taken those 90 hours and we've divvied them up into 3 30-hour post-licensing classes. And you have to complete all 90 hours successfully, including passing the end of class exam, in order to drop that provisional status. That's all you have to do. Now, here's the deal. I can pretty much, I teach post as well. And I can pretty much put all my post-licensing classes, it's pretty much a 50-50 split. Some new agents choose to remain inactive until they complete post and drop their provisional status. And then affiliate with the firm, start their training, da-da-da-da-da. The other half of the class affiliates, has an active license, and then does post licensing while they're working with buyers and sellers, while they're under the direct supervision of the broker in charge. I'm telling you guys, there's no wrong way to do it. Whatever's best for you and your agenda and your goals. Once you get your license, you have 18 months to complete the 90 hours. Please write that down. 18 months to complete the 90 hours. Your 18-month clock starts the date that your license is issued. When you get your license, there will be a date on it, and that is your 18-month clock. Do you have to do post-licensing in order? No. Good question. You can take the 3 post-licensing classes in whatever order you want. Again, some of you choose to be inactive and knock it out as fast as you humanly can. Others of you are ready to go, affiliate with a firm, get active, start working with buyers and sellers. I'm telling you, there's no wrong way to do it, whatever works best for you. Questions on this so far? There is a test at the end of each post-licensing class, but I'm here to tell you right now, post-licensing is not near as intense as pre. Trust me, this is the hard part. Now, with that being said, I need you guys to commit to post-licensing because you have a test to pass. So we still need you to commit, do the suggested reading activities, pay attention, that kind of thing, so you can pass the test. Failure to complete 90 hours within 18 months, and that does mean passing the test. Failure to complete the 90 hours and pass the test within 18 months means if you haven't done all your posts in 18 months, your license will go and remain inactive until you get those 90 hours done. So what if? What if you're in the throes of a transaction? You're working with a buyer and you've been with them for a couple months and you've shown them 50 properties. Your license goes inactive because you didn't do post-licensing in time. Can you still work with that buyer? What do you think? Nope, it's done, isn't it? Game over. So if you're going to go active first, don't let this time get away from you. Is this a 75-hour class? No, it's 3 30-hour classes. The topics of post-licensing, one of them is brokerage relationships and responsibilities, which is just a fancy way of saying agency, units 7 and 8. Another post-licensing class is contracts and closings, which is units 9, 10, and 21. What have I been babbling on about units 7, 8, 9, and 10? And then the third one is North Carolina law and rule. So basically this section, license, law, and commission. All you have to do to drop that provisional status is complete the 90 hours. As a provisional broker, once you're affiliated with a firm, once you're under the direct supervision of a broker in charge, you can pretty much do what a full broker can do. The key is you cannot operate independently as a provisional broker. You must be supervised by a broker in charge. Provisional brokers cannot receive compensation. This is license, law, and commission rule. It's from the comments and the license, law, and commission rule section in the online learning system. As a provisional broker, the only person you can receive compensation from is your supervising broker in charge. So let's say as a provisional broker, you may join a firm that allows you to shadow a seasoned agent. So you're following them, you're watching what they do, you're going with them on listing appointments and buyer consultations and negotiating offers and all this other good stuff. They're letting you shadow the seasoned agent. And let's say the seasoned agent wants you to stuff envelopes so they can send out a newsletter. Can the seasoned agent pay you to stuff envelopes? No, because as a provisional broker, the only person that can compensate you, the only person you can receive compensation from is your supervising broker in charge. Can the seasoned agent pay the BIC and have the BIC pay you? Now we're talking. You can only receive compensation. And it's interesting, again, as we evolve, as things change. There was a rule change in 2020. It used to be that provisional broker could only be supervised by one broker in charge, but they updated. You don't need to know the year, just have it in there for reference. They updated it to say now provisional broker can be supervised by two BICs, as long as both BICs are under the same roof. And this is because the gain of popularity in teams. All teams are formatted and regulated differently. The commission has not weighed in yet on how teams are to be structured. Some people work together and call themselves a team. Sometimes a team is formed as if it were a firm within a firm. They have administrative, they have various tasks, and they also have a broker in charge. So as a provisional broker, you can join a team that's under the supervision of a BIC. The team is under the supervision of the firm, and you can be under the supervision of two BICs as long as they are under the same roof. So the firm would have a BIC and the team would have a BIC. Everybody with me? So as a provisional broker, and that's the only time you can be supervised by more than one BIC, is if they're both under the same roof. Questions on soon to be you guys? My brokers with training wheels. Y'all can ride your bike, but you can't do it without the supervision of a broker in charge. You can't do it without your training wheels. Once you drop that provisional status, you complete post-licensing, you drop your provisional status, and you're just a broker. Sometimes referred to as a full broker. A full broker doesn't have to be supervised by a broker in charge. You can have an active license and not be supervised. Some of you may want to start your own firm one day. Some of you may want to run your own office. We're going to talk in just a second about how you can become the broker in charge. They're going to require you to get a little bit of experience. So the full brokers affiliate with firms. Remember, we're all independent contractors, even the provisional broker. Full brokers affiliate with firms. I'm an independent contractor, so I work for me. I pretty much do what I want to do. However, some firms may have things that say, if you're going to work with us and you're going to follow these rules, if you're going to work with us and you're going to do this. So make sure you read your independent contractor agreement before you affiliate with a firm to learn of any specifics that firm may require. All firms are different. I've always encouraged you guys to talk to 2, if not 3 different firms before you sign on with anybody, so you have something to compare and contrast. I know a lot of you are saying, oh, I've already said I'm going to go work for the firm that my cousin does, and I think that's great. But what in the world can it hurt you to talk to somebody else? Again, that's a question I can't answer for you. So as a full broker, at some point in your career, you may decide you want to become the boss. And that's where we have the broker in charge. We need a BIC under every roof. Every single office location has a broker in charge. If your firm has 5 office locations, one in Greensboro, High Point, Winston, Kernersville, and Burlington, how many broker in charges does that firm need? That firm needs 5, one under every roof. So it's not the number, it's not the firm, it's the office. So every office has to have a broker in charge. There's 2 different things to consider when we talk about the broker in charge. And I can't talk and type at the same time. So, BIC eligible and designated broker in charge. In order to become the designated broker in charge, in order to become the broker in charge that's responsible for the office, you first need to become BIC eligible. How you become BIC eligible. You have to have an active license, cannot be on provisional status. You need to be a full broker. You need to have some experience. They require either 2 years full-time experience or 4 years part-time within the last 5 years. I honestly don't know how they decide what's full-time and part-time. What I know is you need to have some experience. So for those of you thinking you're going to pass my class next week, go take your state exam the first week of June, knock out your post licensing by the end of June, and open up your new firm in July. Guess what? It's not going to happen, because at a minimum, you need those 2 years. Everybody with me? Guys, they're not going to hand you a real estate license and let you run amok on the streets. They're going to hand you the license and make sure you continue to get education and training and real life experience. That's what post licensing is about. So you have to have some experience. And then there's a 12-hour BIC course. I don't think there's a test. I don't know. It's online now. It's asynchronous. So it's like self-paced. So I'm not sure if there's a test or not, but it is a 12-hour BIC course. These 3 things make you BIC eligible. Once you're BIC eligible, you can become the designated broker in charge. Some agents become BIC eligible without any desire to ever become the designated BIC. You never have to be designated, but some do it just for the experience, the knowledge, whatever reason. I know a lot of firms like having a couple BIC eligibles laying around, because what happens if your designated broker in charge doesn't show up for work today? You don't have a designated BIC, your firm's license goes inactive, or that license for the office goes inactive. As a provisional broker, if your broker in charge doesn't show up that day, what happens to your license? As a PB, your license goes inactive too. So it's not uncommon for firms to have a couple BIC eligible laying around. So if something happens to the designated BIC, you can slide somebody in real quick to keep business going. I remember back in my admin days, for some reason, our designated BICs, CE, didn't get reported. It was an accident. Things happen. We found out that the BIC was inactive. We all went to little panic mode, like little panic mode. Like, dang, I need to up my resume real quick, right? Like it's time to go somewhere. They had a BIC eligible, slid them in until they were able to replace, until they were able to give her CE credit so she could be active again. Questions on BIC eligible or designated broker in charge? There's another license category in North Carolina, a limited non-resident commercial broker. Let's break this down. Limited means what? Few. Does that mean a lot? Does limited mean a whole lot? Non-resident, if you're not doing residential, you're doing what? Commercial. So you don't live here, non-resident, excuse me, non-resident means you live in another state. There it is, non-resident, another state, commercial broker. There is a license that allows a commercial agent to come into this state to engage in a limited number of transactions. They have to be sponsored by a licensed broker in North Carolina. But basically, they're requesting from the commission a limited license so they can come in and conduct business, conduct commercial business. So they have an active license, they're a resident in another state. I think the last report I saw, we get the e-bulletin from the commission every month and they always give us number counts. I think the last report I saw, there was like 264 limited non-resident commercial brokers in North Carolina, which is always more than what I expect. So there's, 250 running around with this license. Also, please make a note too, your firm has to have a license. So the firm has a license and then the individual agents have a license as well. Here's a good refresher. We've seen this, the activities that require a license. We can remember LL&CR. We can remember those activities. If you're engaged in list, lease, buy, exchange, auction, negotiate, or selling real property for others for compensation. In this state, a license is required. And please remember, you guys, all three activities are required. So if you're going for sale by owner, you're not doing it for others, are you? Who are you doing it for? You're doing it for yourself. Do you need a license to go for sale by owner? No. All three activities are required. So if and when you see this on your test, is a license required? You need to ask yourself, are they engaging in LL&CRs for others for compensation? Remember, when we talk about compensation, we think about money the most often, but compensation is just anything of value. Let's say, for example, my parents own a duplex. My name is not on the deed. It's my parents' house. It's my parents' deed. Am I doing it for myself? Even though it's mom and dad, I'm still doing it for others. I may be entitled to it one day, but is it mine today? Not yet. So I'm not doing it for myself. I'm doing it for others. And let's furthermore that they say, we're not going to pay you because, we don't want to get anybody in trouble with the real estate commission, but instead we will give you free rent. If you want to live in one of the units and help us manage the second unit. Is free rent something of value? You better believe it is. Would that be something for compensation? Absolutely. So if you were going to manage your parents' unit for free rent, would you need a license? Yes, because you're leasing real property for others for any form of compensation, anything of value. At some point in your career, you may get really busy. Let's fast forward 10 years. And you might be so busy, you decide you need to hire help. Isn't that a bad problem to have? You're so busy, you need to hire help. There's your goals right there. Also, you might affiliate with a firm. It's not uncommon for the firms to have unlicensed employees. So license law and commission rule addresses how we treat unlicensed employees, what they can and cannot do. We're going to look at the list in just a second. Right now, let's understand the unlicensed employee is paid salary or hourly. The unlicensed employee cannot be paid a commission. They cannot be paid a transaction basis. If you hire somebody to work for you 10 hours a week, you pay them for 10 hours regardless if you had a closing that week or not. So they're paid hourly or salary. We talked about employees versus independent contractors at the end of Unit 7. A big difference is with taxes. As an independent contractor, taxes are not withheld from our commission checks. We don't pay taxes until the end of the year. An unlicensed employee, taxes are withheld. That's the difference in a 1099 and a W-9. So they can't be paid on a per transaction basis. They can only be paid hourly or salary. So what I want to do now is get out of this real quick. And I want to go, I'm on license law and commission rules section in the online learning system. And specifically, we're in the comments. And this is where we are. So if we go down to page 3, y'all please make a note of this. Page 3 talks about the activities that an unlicensed salaried employee may do. I suggest you guys look over this list before next Tuesday. I don't know another way to drop that. Okay, so what can the unlicensed employee do? Page 3 of the comments. They can receive and forward phone calls and email messages. They can put listings in MLS. They can do the listing data. They can make changes as long as the information that they're entering was provided to them by their employee licensee. It's a data entry only. Everybody with me? They give you the information, you input it. They can get copies from public records, registered deeds. They can put signs and lock boxes on the property. They can order and supervise routine maintenance, repairs, inspections. They can play courier. The unlicensed employee can provide factual information about the property. I think a general rule of thumb is if you can find it online, then the unlicensed employee can share that to consumer. So if you can find it on Zillow, the unlicensed employee can share that. If it's not on Zillow, then the unlicensed employee needs to send them to their licensed broker. Can schedule appointments for showing or for rent, can communicate with everybody. Inspectors, lenders, licensees, we're all working on behalf of our employing broker. The unlicensed employee can show properties for rent. The unlicensed employee cannot show properties for sale. They can only show properties for rent. Your property managers, it's not uncommon for their office to be staffed with unlicensed employees. They can show properties for rent. They cannot show properties for sale. They can type offers, contracts, leases. They can fill in the blanks of legally binding documents, agency agreements, as long as the information was provided to them by their employing broker. Again, this is data entry only. They hand you a napkin with, Subway napkin with this information on it. They say, put this in the offer. They're data entry only. The unlicensed employee can manage the trust account if the real estate firm has one. We got a whole section for the trust account. We're finally here. We're going to talk about the trust account. They can assemble documents for closing, and then they can compute commission checks on behalf of the firm. So for those of you that are going to get you an unlicensed employee one day, I would refer you to License Law and Commission Rule, specifically the comments, so you can learn the permitted activities. Guys, understand this. Remember, the Real Estate Commission is a licensing governing body. Your unlicensed employee is not licensed. So the Real Estate Commission has no control over them. If your unlicensed employee does something that they shouldn't do, who is the commission going to come after? You, their employing broker. It's your responsibility as the employing broker to make sure that your unlicensed employee is in compliance. Questions? Let's see, some exemptions to who needs a license. We said those 3 activities are required. 4 others, for compensation, transfer of real property. Some exemptions, like we said, the for sale by owner or the for rent by owner, because you're not doing it for others. You're doing it for yourself. So the FSBO and the FRBO do not need a license. Somebody acting as an attorney in fact You have full power of attorney over a parent, for example. If you have full power of attorney and you're selling on behalf of your parent, you would not need a license because you are doing it for others, but you're doing it with a full power of attorney. So the law sees you as an extension of that person. An attorney at law, somebody that's a current member of the North Carolina Bar Association. Attorney at law does not need a real estate license to conduct closings. So our real estate closing attorney may not need a license. They're doing it as part of their NC Bar Association. However, if that closing attorney wants to help his buddy buy a house, now he needs a license. Anyone acting under a court order, so think a guardian or an executor. Again, you've been officially delegated to represent another, so you would not need a license. A trustee, an attorney that's handling it for a lender on a deed of trust. Remember, North Carolina is a three-party state. The grantor, the beneficiary, and the trustee. So the trustee doesn't need a real estate license. They're doing it on behalf of the lender. And then anybody that's employed by the housing authority while dealing with properties owned by the housing authority does not need a license. The housing authority you work for owns property. You're an unlicensed employee. You don't need a license as long as you're dealing with properties owned by. So just a couple exemptions outside from our transfer of real property for others for compensation. Any questions so far? We're getting ready to go full circle. Remember one of the first things you guys learned in this class? The main purpose of the North Carolina Real Estate Commission is to protect the public. We've danced all around our real estate commission. Now we're going to officially introduce you to our real estate commission. The Real Estate Commission is a licensing body. They issue license, they regulate license, they discipline license. They're not going to fine you. They will discipline your license. Bottom line, how much trouble are you going to get in? Bottom line, how badly did you harm their public? Every disciplinary action is handled on a case by case. There is no across the board because every member of the public is unique. Every situation is unique. And so all disciplinary actions are also unique. How badly did you violate license law and commission rule? And again, the big question, how badly did you harm their public? That's their purpose, you guys. They're not here to give us a license. They do, but that's not their main purpose. You got to prove to the commission that you deserve a license. How do you prove that to the commission? You pass this test, you pass your state exam, you pass your application, your character review, criminal background check. So our commissioners, there are 9 of them. There are 9 commissioners. They serve 3-year terms, usually about three a year. Specifically, they say of the 9, at least 3 must have an active real estate license. So at least 3 of your commissioners are at least involved enough that they have a license. Also, out of the 9, at least 2 do not have a license. At least 2 of your commissioners haven't even been this far. They haven't been a pre-licensing. They don't have a license. Isn't that a true representative of the public that they're representing? So they have people that don't have the license. They're not involved in real estate because that's who we're protecting. So at least 3 have to be brokers. At least 2 are not involved at all in real estate. So what do? How do they protect the public? Well, as we said, they issue your license. Once you've proved to them that you have the minimum competency. Minimum competency. How do you prove that to them? Pass this class, pass the state exam. That's what you're doing. We danced all over lots of topics. You guys have a lot more to learn. Don't think you know everything, because you know what? You don't. We've scratched lots of surfaces in this class. And by passing the exams, by submitting your application and your background check, you've proven to the commission that you have the minimum competency for them to issue you a license. The only other educations you're going to get from the Real Estate Commission, they do provide pre-licensing while we're here. The Real Estate Commission provides us with post-licensing. And then the Real Estate Commission also gives us our continuing education that we're required to do each year that we will talk about. So pre, post, and CE. Guys, that's all the education from the commission. Any other education you get is from your firm, local board of realtors, National Association of Realtors, NCAR has some education. It's up to you guys. Outside of the pre, post, and CE, it's up to you guys to get further knowledgeable about the areas you want to work. Property management, residential, commercial. There's so much training out there. I'm going to encourage you guys now to take advantage of what you can. You're going to have to pay member dues. All those membership, local board of realtors, state, national, all those cost dues. And I hear a lot of time, my money goes to nothing. Well, these are the people that don't take advantage of the education opportunities. That's part of what your dues goes towards. And please don't ask me how much dues are, because they're all different. I see you guys typing. Back. They're all different from board to board. Your firm will introduce you to the dues when you start talking to them. In addition to educating licensees, future licensees, and brokers, the Real Estate Commission also helps to educate the general public. We just talked about those Q&A brochures that are available at ncrec.gov. They have brochures and literature and videos, publications. It's a public site, which means anybody can access it. And they're trying to help educate the public when dealing with us. As we know, the commission also has the power to discipline your license should you harm their public or should you violate license law and commission rule. They do have the power to make reasonable bylaws, rules, and regulations. That's the CR commission rule. So license law is a general statute by the state of North Carolina. Commission rule or real estate commission rules that they've implemented and have had passed. So they have powers to make reasonable bylaws, rules. And one thing that the commission will never get involved in is our money. So they are not going to make rules and regulations on your commission, salaries, fees. Guys, bottom line, if you're not happy with the commission split you're getting at your firm, go to another firm. Don't call the real estate commission. They can't help you because they don't get involved with matters of money, with fines, with fees, I should say. The other thing that we know is that the commission isn't going to fine you. They're going to regulate your license. There's only one incident that the commission can fine you. Does anybody remember that? Oh, I see hands going up. I see question marks. Anybody want to remind us? Yeah. That's it. The only time that the commission can fine a licensee are timeshare developers. Unless you're a timeshare developer, you cannot be fined by the real estate commission. Everybody with me? You can be fined by the court. You cannot be fined by the real estate commission. Can somebody sue you? You better believe it. That's right. Specifically, they have the power to fine the timeshare developer up to $500 per violation. If you do violate license law and commission rule, they may seek disciplinary action. The real estate commission can seek disciplinary action on their own. They can take it from a complaint if they have reason to think, for whatever reason, that you're violating license law and commission rule. Then they may launch their own investigation. If somebody files a complaint against you, again, you're not automatically going to lose your license. The first thing the commission is going to ask is this a violation of license law and commission rule? If somebody hires an attorney, there's a really good chance that the attorney is going to notify the commission, which would cause them to launch their own investigations. Yes, it is, but that's not with the real estate commission. If you get yourself in trouble, so somebody files a complaint, they send you a letter of inquiry. The letter of inquiry is your opportunity to respond to the complaint. The letter of inquiry, you're not done yet. The letter of inquiry is your opportunity to respond. Guys, the real estate commission understands that there's 2, if not 3 sides to every story. So just because somebody files a complaint on you doesn't mean you're going to get in trouble. Is that fair? The commission gives you the opportunity to respond. The commission gives you the opportunity to say, I did or did not do this. How do you think you're going to respond? Do you think you're going to be able to pick up the phone and call them and say, I didn't do it? I see head shaking no. The only acceptable response to a letter of inquiry is with your documentation. So what do we document? Every stinking thing. Yes, and Erica's, that's correct. Yep. Everything. If you have a conversation with somebody of substance, face to face or on the phone, when you get home or you hang up the phone, I need you to send an email talking about per our conversation. Everybody with me? You make a note on a subway napkin, you put it in your transaction file. It's your documentation that's going to save you. So you respond to the letter of inquiry with your documentation. They may ask for more. They may want to investigate further. They may require a hearing, which means you get to go to one of the monthly meetings and stand in front of the commissioners, state your case. At any time throughout the process, we are always welcome to have our own attorney. We can always have our own representation. So if you get called, if you get the letter of inquiry, you want to talk to an attorney, if you get called to go to a meeting to state your case, you're welcome to have an attorney. So now that I have a little bit of fear in you guys, how do we keep you from getting disciplined? How do we keep you out of real estate jail is what we affectionately refer to it as. License law 93A-6. And this is the license law that's in the Julie folder, formerly called the Campbell folder. License law 93A-6 tells you the various actions that the real estate commission can discipline your license. It's in the Julie folder. One of 2 I've asked you guys to read, 93A-6 and Commission Rule A.0104. Julie, formerly referred to as the Campbell folder. If they find you're guilty, they can do various things. Censure or reprimand is kind of a slap on the wrist. They may say, don't do that again. They may say you need to take an extra CE. You know, if it's a violation of agency, maybe they'll make you go back to post licensing, right? So they may require additional education, but a censure or reprimand is just a slap on the wrist. If your license gets suspended, you're going to lose it for a period of time. Maybe it's a month, maybe it's 6, maybe it's 2 years. Again, it's all a case by case. Worst case scenario, they revoke your license. You know you've messed up when, right? So if they revoke your license, they take it back. They pretend like it never existed. You won't get licensed again in this state. You probably won't get licensed in another state. Again, how can we stop this from happening? 93A-6. That's what this class is about. I think I told you guys on day one that my job is to prepare you for the state exam. That's what I do for a living. I prepare you guys for the state exam. I'm not here to teach you how to be agents and how to put together open house goodie bags. That's not what I do. My job is to prepare you for the state exam. But I always feel like my job is twofold. Not only am I preparing you for the state exam, but I also want to help keep you out of trouble once you do get your license. And that's where 93A-6 plays a big part. That's what this class is about, is setting the parameters for you guys. You also have the ability to surrender your license, just give it back if you don't want to go through the investigation. I think you sound kind of guilty, but hey, if you don't want to go through the process, you can just surrender your license and be done. Once you guys are licensed, I need everybody to understand that when you're selling, leasing, or buying for yourselves, you're now held to a higher standard. Because yes, you're doing it for yourself, you're buying, selling, leasing for yourself, but guess what? You are communicating with the public. The other side of that transaction is the public. Do you know more than they do because you have a license and they don't? Absolutely. And the Real Estate Commission cannot let us take advantage of that situation. So once you're licensed, when you're dealing in exchange of properties for yourself, you're held to a higher standard. The commission or the court may put in an injunctive relief. An injunction is just a legal stop. So if the court or the commission issues you an injunction, you're not working while this is being investigated. They can also put an injunction on an unlicensed person. They can stop them from those activities. Remember, they got to discipline the broker, but they can put an injunction on an unlicensed person. And remember, any violation of license law and commission rule may also be held in a court of law. It depends on how badly you injured the party and what they want to do about it. How far do they want to go? Questions on the commission. Who they are, what they do, who you answer to. By the way, they're lovely people. I've had the opportunity, several of our commissioners are involved in the education department. So I've had the opportunity to meet with, even shake some hands. They're humans, you guys, they're people, I've met them. All they ask is that we do what's right. What's right? License law and commission law. That's why we're here. Questions? Can a licensee buy property for themselves? You better believe it. Buy, sell, lease, all day, every day. But I'm held to a higher standard. My husband and I bought this house 3 years ago, almost 3 years ago. I got to wear two hats in the transaction. I was the buyer and I was the buyer's agent. First communication I had with the listing agent, what do you think I said? I have an active real estate license. He said, cool. I put that up front. I disclosed that. So he knew where I stood coming in to the transaction. What's your commission? Commission is set by the firm. So you're going to get paid both commissions. Commission is set by the firm. Questions? Real Estate Commission, comments? I remember when we went to closing, you know, we talked about unit 21 and we go to closing and we want to go to closing with our clients. You know, I mean, my gosh, we've been through them since day one. So why aren't we going to closing with them? So my husband and I were buying this house. We showed up at the attorney's office and I said, you know, we're the Campbells. here for our appointment, whatever time to sign our paperwork. And that receptionist looked at me with such pity. She said, did your agent not come with you? And I said, well, I am in one of the same. She went, oh, that's right, that's right. But the very fact that she thought that buyers were there without representation just broke her heart. I was like, no, I'm one of the same. And she was good. You can represent yourself in a transaction. Yes. I was buying. I was acting as a buyer and a buyer's agent. So I had two roles. Darn right, I made my husband sign the working with real estate agent disclosure. Yes, we entered into a buyer agency agreement. Why? Because that's what license law 93A-6, that's parameters of my job as a buyer's agent. I signed it too, by the way. Right? When in doubt, just sign it. So everybody asked me, did you have to? I don't know, but you know what my documentation has? It has that we sign that stuff. Other questions? All right, let's go ahead and take our last break. We come back, we keep going in license law and commission rule. We're back. I am taking attendance. Moving right along in the comments, this next little section is good because it kind of serves as a review. Review meaning we've already talked about this stuff, so we're just going to remind you of it. We've had full-blown conversations, and one of those things that we're going to review in license law and commission rule comments are material facts. So if you guys will, please turn with me to page 143 in your book. The comments does spell out material facts, what are and are not material facts, but you have something to look at. We can look at page 143. I do encourage you guys to look at material facts and the prohibited acts in both Unit 7 and the comments. If we're giving you information from two different sources, if we're talking about it twice, what does this mean to you? Kind of sort of important. Y'all want to know what the biggest complaint that the commission has been over the last 2 or 3 years? The number one complaint with the commission by consumers: mishandling material facts. So hopefully we're getting this to you guys early so you can learn properly. This is all we've done CE on is the last 2 or 3 years. And I think it was this year as well. So what things are considered material facts? Page 143. Material facts are facts about the property itself. Are there structural issues? Are there electrical problems? Does the roof leak? Does the basement flood? Material facts are facts relating directly to the property. Is NCDOT planning on widening the road? Is there a zoning amendment on the table? Are they going to redraw the school board lines? Material facts are one directly related to the ability of your principal to complete the transaction. And I think that one is the hardest one for us to get. Because if we remember old car, and the C in old car is what? Confidentiality. I tell my client I'm not going to share your confidential information. However, if your client can't complete the transaction, is that not important to the other side? Absolutely, because it affects the other side. If your principal, if your client cannot complete the transaction, we have to notify. That is a material fact that we have to share. Let's say, for example, your buyer, you find out your buyer can't get loan approval. Assuming, unless they got cash stuffed around somewhere, stashed around somewhere, if they can't get loan approval, can they buy the house? No. And isn't that important to the seller? Wouldn't that be important to you if you were selling? Absolutely. That's why it's a material fact. It's directly related to the ability to complete the transaction. And then the fourth one there is kind of a separate little category. It's a fact just for us. That takes me back to my super simple philosophy. If it's important to my buyer, then it's important to me. If it's important to my seller, then it's important to me. Any fact known to be of specific importance to a party. What if your buyer tells you, this is one that just came up this last year in CE actually. What if your buyer tells you that they have a severe allergy to dogs and they can't live in a house that had dogs? Do you now have a material fact on your hand when you go out and show property? Yeah, it may not be important to all buyers, but didn't your buyer tell you that was important to them? So now you have a duty to make sure, pick up the phone and call the listing agent. Can you find out if your sellers had pets? Can you find out if your sellers had dogs? That's what we mean, you guys. You're not going to advertise it. You don't have to put it in the remarks in Zillow. My buyer's allergic to dogs. It's a material fact to you, something that's a specific importance to a party. Then over on page, skip ahead with me just a bit, on page 146, we talked about things that are not considered material facts in North Carolina. You go to other states, they may handle these differently, but in North Carolina, stigmatized properties are not a material fact, death or serious illness. We just said back in Unit 19, the exception to that rule is anybody that's had AIDS or HIV. And then another thing not considered a material fact is the presence of convicted sex offenders nearby. When it comes to that, be the source of the source. Send your buyers and tenants to the sex offender registry website and let them look it up, let them do their own investigations. So it's important that we know the things that are material facts and the things that are not. And by the way, when I say they're not considered a material fact, that means we don't have to volunteer the information. So if somebody died in the house, I don't have to volunteer that. However, if I'm asked, we must answer honestly. Sometimes these high profile crimes that hit the news and the neighbors know, you know what neighbors like to do when they see buyers coming to look at a house? Man, they talk. As a buyer's agent, nothing makes me more nervous than a neighbor popping up. Yoo-hoo! Dang it. So something like that, maybe it might be best to disclose, right? Because if you don't, then the neighbors and the news, right? So it's a case by case. But what we're saying, what we need to understand, it's not a material fact, meaning we don't have to volunteer the information. So what happens if you don't handle material facts right? Well, basically, there's one of two ways you can mishandle a material fact. You can either misrepresent it. Don't pay attention to the first words there at first. You can either misrepresent it. A misrepresentation is a lie. You have put false information out there. Maybe you meant to do it, maybe you didn't. Doesn't matter. You put false information out there. You have misrepresented a fact about the property. The other way that we can mishandle material facts is by omitting it. An omission means you kept your mouth shut. You didn't disclose. You didn't volunteer the information. So what are the two things that we can do wrong with material facts? Either lie about it or keep our mouth shut. We always have a duty to disclose material facts. Gee, that's worth me saying again. We always have a duty to disclose material facts. I don't care if you're working with a client or a customer. We always have a duty to disclose material facts. Your role does not matter. Are you a listing agent, a buyer's agent, a seller sub-agent, a dual agent, a designated dual agent? We always have a duty to disclose material facts. Everybody hear my big absolute word right there? Always. Customer, client. And how they're mishandled, how they get complaints to the commission is when brokers either lie about them or omit them. Again, you did it on purpose or not, willful versus negligent. You did it willfully, you did it intentionally, you had actual knowledge. Negligent means you didn't mean to, but it still happened. There are examples for all four of these prohibited acts, both in your book, on Unit 7, starting on page 144 over to 146. You also have additional examples on each of these in the comment section. So if you haven't read that comment section, I'm really encouraging you guys to. So material facts, you know you can see these again. You'll see these in post licensing and it'll probably keep coming up in CE until the number of complaints starts going down. Continuing on in the comments. Now, we briefly mentioned some additional duties on page 147, but if you look in the comments, or when you look in the comments, there's some additional duties, some additional things we need to know. So the comments not only gives you an explanation, but it gives you other examples. I'm such a big fan of the examples because I think it helps us better understand it. So again, I'm asking, directing you guys to read those comments. So some additional duties, I have to avoid making false promises. I cannot make any promise that's going to influence or persuade somebody to enter into a contract for lease or for sale. If I'm making any promises, they need to be accurate and I need to stick to them. Don't make any empty promises. This does include your advertising. This also includes conversations and discussions with other agents. If you tell somebody you're going to do it, do it. So we have a duty to avoid making false promises. What if you do half of your promise and I guess you're going to get in half of trouble? I don't know. You know, it's all case by case. So what half did you do? How badly did it harm the public? Just do what you say. Another thing we need to avoid as licensees is a conflict of interest. Anything that goes between myself and my client, I got to avoid those conflict of interest. Guys, remember the very first thing we learned about agency? Agency is not about you. Agency is about your client. Agency is about your principal and what's best for them. So we have a duty to avoid any conflicts of interest. Examples of a conflict of interest: undisclosed dual agency. Undisclosed dual agency means we just start acting like a dual agent without disclosing those terms, without going over what it means to be a dual agent and how does that affect our buyers and sellers in that transaction. We just can't start acting like a dual agent. Remember, dual agency is intentionally created with informed written consent. Another conflict of interest is self-dealing, earning a secret profit, or not sharing information about the property. And then you think you're going to buy the property and use that information to your advantage. Whose best interest do you have right there? Is it your client's? No, it's yours. Those are the conflicts of interest. There's a great example in the comments that I like about self-dealing. It says you're getting ready for a listing appointment and you're doing your research on the property. You learn everything about the property you can. And in doing your research, you find out there's a zoning amendment on the table. And if that zoning amendment passes, it's going to increase the value in that neighborhood, in that area. So you learn this little tidbit of information. You go to the listing appointment, you're having a conversation with the seller who never mentions this zoning amendment thing. And you think to yourself, gee, I wonder if they know about it. And you look at your seller and you say, I'll tell you what, I really like this house. So instead of you going through the process of putting it on the market, how about I just buy it from you? And the seller says, wow, that's easy. Where do I sign? You buy the house, it closes, the amendment happens, the value goes up, and you sell it for a profit. Is that self-dealing? All day long. Now, what if, let's go back. What if you're at the listing appointment, the seller doesn't mention it, and you bring it up? And you say, I found in my research this zoning amendment and it could increase the value. And the seller says, I appreciate you sharing that with me, but I have to sell now. I don't have time to wait. Now, can you offer to buy the house? Yeah, because you disclosed it. You disclosed that information. The seller, you allowed the seller to make the choice. Does this make sense? If the seller says, oh my gosh, that's great news, I'll call you back in 6 months when this value goes up, you've got to share that information. We've got to disclose. Don't act for something that's in your best interest over your clients. The other conflict of interest is representing another broker without consent. As a full broker, you can have 2 BICs in 2 different locations. As a full broker, you can be dual affiliated as long as you have both BICs consent. My firm, for example, only does residential. That's all we'll do. We're going to refer everything else out. Commercial, property management. We chose to only do residential. And let's say I have an opportunity to engage in commercial. I might be able to dual affiliate. I might be able to hang my license with one firm to do residential and another firm to do commercial. And that's okay for me to do, as long as I have consent of both brokers. Commercial bit knows about residential bit knows about commercial bit. Does that make sense? We've got to disclose if we're dual affiliated. Another thing we have to avoid, another duty to avoid, improper brokerage commission. As we've said, your unlicensed employee is hourly or salary only. They cannot be paid a commission or a referral fee, a bird finder's fee, anything like that. And we said earlier that the provisional broker can only receive compensation from their supervising BIC. Recent rule change now says any affiliated broker, full broker or BIC eligible, is prohibited from receiving payment from anyone other than your supervising BIC. So that builder bonus that we've talked about a couple of times, that the builder's offering you $500 with an acceptable contract by the end of May, that $500 has to run through your firm. Are they going to pay you the full amount? Are they going to pay you on your commission split? That's up to the firm's policy, how they handle that. What I need you guys to understand is none of us can take a commission, can take that bonus directly from the builder. All monies have to run through the firm. Another thing we have to avoid, they don't let us have any fun. We can't act unworthy or incompetent. No fun. When in doubt, find out. If somebody asks you a question, if you don't know how to properly fill in a form, if you're not sure, we have a duty as the professional in this transaction to find out. That's why they hire us, you guys. So we can't act unworthy. We can't act incompetent. Now, we've harmed the commission's public. So all of our services under license law and commission rule, like I said, filling in the blanks, verifying that your buyers and sellers closing statement is correct. That's a duty that we have. That's a duty that we owe them. If the buyer's agent gets a bonus from the commission, should they disclose that to the buyer? Yes. And we're going to talk about that. We got to disclose our monies. Yep. So we're getting there. I can't act improper. I can't engage in fraud. I can't be dishonest. My gosh, they don't let us do anything, do they? We have to conduct ourselves in a professional manner. We are the professionals in this situation. They're not going to handle lying or dishonest behavior. Any failure to exercise your reasonable skill, care, and diligence. What's the R in old car? Reasonable skill, care, and diligence. We have a duty to avoid discriminatory practices, any violation of fair housing, may that be federal fair housing or state fair housing. It can be seen as a violation of license law. So again, making sure that you're helping to educate the consumer about fair housing, walking away from transactions that they refuse to comply with fair housing. Again, I can't answer that for you, but if your license is, if your career is on the line, is that one commission worth it? You know, that's a question for you guys to answer. We have a duty to avoid practice of law. We cannot perform legal services. I cannot draft legally binding documents. My job is to fill in the blank. They provide me with the legally binding documents. I fill in the blanks with a discussion with my buyers, sellers. I cannot tell people how to take title. So if you are working with unmarried buyers, are you going to whip out your pre-licensing textbook and explain Tennessee and common and joint tenancy to them? Everybody shake your head no. We're going to tell them to do what? Talk to their attorney. The attorney can advise them how to take title. We taught you just enough to be dangerous. The attorney can tell them to take title, how to take title. They're going to provide the information and see which one works best for them. Guys, this is so important. I think we talk about this 3 or 4 more times in this section. Please understand, always remember, it's not the consumer's job to know the parameters of my job. It's my job to know the parameters of my job. Consumers are going to ask you. Consumers all the time are going to say, can't you just delete this provision? Can't you just add this? Can't you just do this and that? And when it comes to drafting or creating legally binding documents, what's our answer? No, we are not attorneys. Have you guys started your morning affirmations? You should be looking at yourself in the mirror saying, I am not an attorney, because it's so important to remember, because it comes up a lot. So we need to know how to respond to that. There's kind of a catch-all provision. Any violation of a commission rule. Again, we're just introducing you to it. In the comments, we've touched on rules all throughout this class. So any violation of a commission rule and license law could be subject for disciplinary action. Again, for the commission, it comes down to how badly did you harm their public? That's what they're asking. That's what they're looking for. And then the last things that we can't do, there's this kind of list of other. Obtaining your license fraudulently. Y'all don't lie on your application to get your real estate license. Fair enough. If they find out that you lied on your application to get your real estate license, you will lose said real estate license. How do they find out? Doesn't matter. Doesn't matter how they find out. Y'all want a great example? Probably about 7, 8 years ago, there was an agent in Greensboro that got caught lying on their application for their real estate license. Want to know how? Because his ex-girlfriend turned him in. Careful what those exes know, y'all. Seriously, it doesn't matter how they find out. Once they find out you lied on your application, you could lose your license. He did. Conviction of a misdemeanor or felony once you're licensed. Now, we're going to talk more about that. We may not get to it today, but we will talk more about that. We all know you have to do a criminal background report to get your license, but you're not off the hook. Once you are licensed, if you get yourself in trouble with the court, may it be a felony or a misdemeanor, we've got to report it to the Real Estate Commission. Are they going to do anything? I don't know. If you don't report it, you're facing disciplinary action. So there's specifics. We'll talk more about this, specifics on how long you have to report it, when you have to report it. So we'll see that again. Similar to that is disciplinary action from another professional license. Does anybody else have another occupational license? CPA, CNA, for examples. If you get yourself in trouble with your other professional license, your other occupational license, you've got to report it to the commission. What are they going to do to you? I don't know. They're going to review it on a case by case, but we have a duty to report it. And again, failure to report it is a violation of commission rule. And then there's those wrongdoings of unlicensed employees. Again, If you are bringing on an unlicensed employees, you are responsible as their employing broker for their actions. So the comments list all of these additional duties. They all have really good examples. Another review covered in the comments. We're going to talk about your agency agreements. We're going to talk about working with real estate agent disclosure. We're going to talk about the different types of agencies. So again, this is stuff we're giving you both in unit 7 and 8 and also in the license law and commission rule. So let's talk first about our written agency agreements. Written agency agreements must eventually be signed by all parties. Please always remember, your agency agreements are employment contracts. They use the agency agreements to hire us to do a job. The listing agreement is hiring us to list and sell the property. Buyer's agency agreement is hiring us to help them locate and purchase a property. Property management is hiring us to manage their property. Their employment contracts, employment agreements. So they must be signed by all parties. Anytime you're working with an owner, agency agreements must be in writing from the inception. I cannot perform a single service for an owner without first having a written signed agency agreement. The commission does allow us to work with a buyer or a tenant under an oral agreement at first. Oral agreements at first. The latest we have to put our oral buyer agency agreement in writing is before we're presenting an offer on the buyer's behalf. So owners must have a signed agency agreement from the inception. Buyer tenant does allow us to work with them under an oral agreement at first, but eventually it too needs to be put in writing as well. We talked about our musts of our written agency agreements. Got to be signed by all parties. Remember, the agency agreements are between the client and the firm. You, as an independent contractor, are a general agent of your firm. As a general agent, you have some power, some ability, some authority. And an example of the power, the ability, the authority you have is to sign the agency agreement on behalf of your firm, because you're a general agent with your firm. So we sign the agency agreements. Because we sign it, we need to include our license number. Anything you sign will include your license number. You get a 6-digit number on your license when you receive it. Go ahead and memorize it because you need it everywhere you go. Our agency agreements have a definite end date. For listing and buyer's agency agreement, when they're over, they're over. Property management does allow us for an automatic extension, an automatic renewal, but that's property management only. And then all of our written agency agreements have our non-discrimination clause. So let's go back and talk about that oral buyer for just a second. Please remember, always remember, oral buyer agency is buyer agency. And in an oral buyer agency agreement, we owe that buyer OPAR. How do I get away with that? How do we do that? Because it's an express agreement. Please pay attention to express versus implied. Express meaning the terms have been clearly stated. So how can we have an oral buyer agency agreement? How can I owe somebody old car if we don't have anything in writing? Because it's an express agreement. The terms have been clearly stated. So even if it's oral, aren't I still having a conversation with them? Aren't we still discussing what it means for them to be my client? That's what we mean by express. You just don't start acting like somebody's agent. So we can have an oral buyer agency agreement until the time we're ready to present an offer on their behalf. We don't have to commit anybody to us, but I cannot present an offer as a buyer's agent without having something in writing. So what if we're ready to sign this agreement or present the offer, ready to present the offer, and I tell my buyer, my oral buyer, I need you to sign this. And they say, nope, I'm not going to sign it. Guys, I cannot present as a buyer's agent without having a written buyer agency agreement. We could try to have them sign a buyer agency agreement just for one address. You remember when we looked at our buyer agency agreement, there was a place for me for the general location. So I could enter into a buyer's agency agreement with just 123 Main Street. If they still refuse to sign, the last ditch effort says we try to switch them from being a client to a customer. We can try to downgrade them from first class to coach. The commission says switching as a buyer's agent to a seller sub-agent is not encouraged. It is the last ditch effort. Quite frankly, if we're doing our jobs right to begin with, why wouldn't they want to sign? Exactly. So if you find yourself in a situation where you try to present an offer and the buyer says, I'm not going to sign it. You try to present another buyer and a different offer and a different buyer says, I'm not going to sign it. And the third buyer and the fourth buyer, you don't need to be looking at all the silly buyers out there, don't you? You need to be looking at you and your practice and how you're doing this. Is everybody with me? So make sure we're presenting ourselves properly up front. Why wouldn't they want to sign? But understand what we're getting from this slide. I cannot present an offer as a buyer's agent with an oral agreement. If I'm presenting it as a buyer's agent, I'm putting that thing in writing. So what if they say, no, I'm not going to sign it. No, I don't want to switch. I don't want to be your client. I don't want to be your customer. Guys, I only have two legal alternatives to work with people. Either you're my client or you're my customer. And if they deny either one, I'm out. I have no other legal alternative. This is all we got. Either my client or my customer. Again, unit 7 and 8. We talk about oral buyer agency. Again, here in the comments. Also in unit 7, we talked about you're working with real estate agents, agent disclosure. Agency disclosure is just that. It is me disclosing my agency status to the consumer, not necessarily when we first meet, but when the conversations start switching gears from the property to the people. When we start learning about the people, when we start asking questions or they start volunteering, that's when we need to make sure that we do our working with real estate agent disclosure. Commission rule actually says before first substantial contact, but that's like a fine science. It's hard to do. What we need to know is we always need to be on alert. And as soon as we suspect that that conversation is switching gears, people like to talk. It amazes me how people talk. We need to be on alert for people talking. That's what we're doing, is disclosing our agency status. And the most important thing about the working with real estate agent disclosure is letting that consumer know that I don't owe them confidentiality until and if they decide to hire me. Remember, it's only the client that gets confidentiality. So if you never hire me, I don't have to keep any of your secrets. Don't you have a right to know that before you start telling me all your terms and motive and why you want to buy and how much you're willing to buy? Isn't that only fair that I let you know? And that's what we're doing with the working with real estate agent disclosure. Again, we have to disclose. Handing them the disclosure is not enough. Say, read this tonight before you go to bed. That's not enough. We have to disclose. We have to have a conversation. The document itself is just there to assist us. Also remember, working with real estate disclosure applies to sales transactions only when you're working with buyers and sellers. Is commercial sales a sales transaction? Are you working with buyers to help them buy a commercial property? Are you working with sellers to help them sell a commercial property? Absolutely. Sales is sales, may it be residential or commercial. With sales, we're working with buyers and sellers. It is not required in property management, tenant landlord, just sales transactions only. Yeah, we'll see that again in just a second. So a couple rules as a reminder. On disclosure of our status by the seller's agent and sub-agent when you are talking to prospective buyers. That's when we disclose our status at first substantial contact. I'm getting some questions about first substantial contact. You come into my open house, do you tell me, hi, your name is Bob? Did I learn anything about why you want to buy, why you want to sell, what your motive is, how high you're willing to go? No, all I know is your name is Bob. We've not hit first substantial contact. Now, when Bob stands in my open house and says, oh my God, this is my dream house and I would pay much more over asking price. Did we just learn something about Bob in this transaction? That's when we've hit first substantial contact. We can talk about the people all day long until they hit on their price, term, or motive, PT or M. How much are they willing to pay? How much are they willing to sell? What are their acceptable terms? And why is their motive for buying or selling? Those are our alerts, you guys. PTM, price, term, motive. So as a seller's agent or a seller sub-agent, when you're communicating with prospective buyers, we stop the conversation. We do our disclosure with prospective buyers at first substantial contact. If you've already been hired as a buyer's agent, you are a buyer's agent communicating with sellers. Now we have a duty to disclose that initial status. So let's say you're a listing agent. My buyer has a question. I call you and say, hi, my name is Julie. Have we had initial contact? Don't I need to follow that up with? And I'm working as a buyer's agent. I don't need to wait for us to hit first substantial contact. Once you've been hired as a buyer's agent, whenever you're communicating on behalf of your buyer, may that be directly to the seller or the seller's agent, we have to disclose our status at initial contact. Now, obviously, I'm not doing the working with real estate agent disclosure with another agent. That's why we're talking about disclosing of our agency status. So first substantial contact is when we start learning that PTM, price, term, and motive. Initial contact is when we say, hi, my name is Julie. The next thing that falls out of my mouth, it better be, I am a buyer's agent. Had a question come in. I can't remember if it's covered here or not. But remember, we talked about auction sales. Agency disclosure is not required in auction sales. But guys, please listen. Yeah, it's in the comments, so we may get to it in a second. Please listen to me. Auctions don't exist until the question specifically says something about an auction sale. So pretend that they're not even a thing unless the question says something about an auction sale. And we will see that slide in just a second. Just want to make sure I got it covered just in case. Still review an agency. Is this a good review? I like this in this part of the class because I hope a lot of things are, or question marks are popping up, which is encouraging you to go back and review that material. It's working one way or another for you. We also talked about dual agency. There's our auction slide. It's coming next. How do we create dual agency? Does it happen by accident? No. Do we just start acting like a dual agent? No. Dual agency is intentionally created with informed written consent by both parties, both buyer and both seller. Remember, the simplest breakdown of dual agency I can offer you: one firm, one transaction, two clients, which means we have no customers in this transaction, and dual agency is one or two brokers. I can't get any simpler than that. Dual agency is one firm helping the seller sell 123 Main Street, the same firm helping the buyer buy 123 Main Street. One firm, one transaction, two clients. Both buyer and seller have hired you, so there are no customers. Maybe you have one broker working with both. Maybe you have two, one working with the seller, one working with the buyer. It doesn't matter. In dual agency, it's about the firm. The firm has been hired by both buyer and seller. Because we can do an oral buyer agency agreement at first, we can also get an oral consent to buyer agency until it's time to put it in writing. We'll touch on designated again in just a second. And here in the comments is our auction sales. Not going to have dual agency because the seller of the auction sale is only going to hire the auctioneer. The auctioneer is not going to work for both. And we don't have to do the working with real estate agent disclosure in an auction sale because it's presumed that the buyer knows that the auctioneer represents the seller. Again, don't worry about auction sales until the question specifically says something about an auction sale. Can I get some thumbs up that you guys are hearing what I'm saying? Auction sales don't even exist unless the question says something specifically about an auction sale. You go to the auction, maybe you're a buyer's agent, you take your buyers to an auction, gavel comes down, the auctioneer can bind the seller. Once that gavel comes down and they say sold, just that, we're under contract. Now the agent has a duty. Next thing we need to do is put that binding agreement in writing. And now the buyer's agent has a duty to disclose their status. Hey, I'm a buyer's agent. So auctions are a totally separate category, totally different beast, if you will. As we said, dual agency is about the firm. Dual agency is not about the individual brokers. It's about who does the firm represent. And if the firm represents both the buyer and the seller in the same transaction, then we're in dual agency. We need informed written consent of all parties. Remember our agency wall? So on our agency wall, on one side of the wall, we got the buyer. On the other side of the wall, we have the seller. And who's straddling the wall? The firm and all the agents. We are straddling the wall and giving both parties fair and equal service. The big thing that happens in dual agency is that the firm's advocacy goes away. I can't advocate for one party without harming the other. I can't give advice to the buyer that wouldn't harm the seller, and vice versa. So in dual agency is not what's best for the clients. Dual agency is what's best for the transaction. You have two clients that want to be involved in this one transaction. So how can we make this work? We as the firm have to take a few steps back on what we can offer, the services we can offer. And remember, agency all started back in the days of England, when we had a king. Did we have two kings back in the days of England? No, but that's what we're doing in dual agency. We're representing two kings. If the firm allows it, the firm has to allow it. It's not automatic. If the firm allows it, we may have the opportunity to bring in designated dual agency. Still a form of dual. I have to have a yes to dual before I can get a yes to designated. And now what happens in designated? One agent gets kicked off the wall to work exclusively with the buyer, and a different agent gets kicked off the wall to work exclusively with the seller. Those two agents have been designated. And now that these two agents are designated, they might as well proceed as if they were with two different firms. You see that line between them? Now they're bringing back full representation, full exclusive representation. These two agents can give advice. These two agents can advocate for their respective client. Look at where the firm and everybody else still is. The firm and all the other agents are still in dual. They're still straddling that wall. Again, the firm has to allow designated. They have a policy. They have procedures in place on how to handle this. Please hear me. Designated is not automatic. Designated becomes, it's better for the clients. Designated brings fairness back into the clients. And I think that's where we get this, because we always want to do what's best for the people. That's in our nature. We want to do what's best for the people. And I think we can all agree designated is a better deal than dual agency for the people. So we tend to think, oh, why wouldn't a firm offer it? It should be automatic. It's not. The firm has to offer it. The firm has to allow it as an option. There's two caveats to designated, two reasons you may not be designated other than the fact that the firm doesn't offer it. Two agents cannot be designated if they have received prior confidential information about the other side. If you've received prior confidential information about the other side, you cannot be kicked off the wall because you go into that with an advantage. Once you've been designated, if you learn something confidential about the other side, don't you have a duty to share that with your client? Once you've been designated, once you've been kicked off the wall, that's what it means to be designated. Designated brings back exclusivity. So once you've been designated, if you learn something confidential about the other side, we owe it to our party to tell them. The other big caveat in this thing is probably the problem topic in pre-licensing. The broker in charge and the provisional broker cannot be designated opposite of each other. Let's do some yes, no, shake your head questions. Can the BIC and the PB be in dual together? Can they be in dual? Can they be in dual? Yeah, because dual's about who? The firm. They cannot be designated. Remember, we just talked about the provisional brokers under the direct supervision of the designated broker in charge. If the BIC is doing their job, they know something about the PB's clients. The BIC prepared you, maybe even went with you to the listing appointment. The BIC prepared you and maybe even sat with you during the buyer consultation. Everybody with me? So if the BIC's doing their job, they know something about the provisional broker's client. And because of the nature of their relationship, they cannot be designated opposite of each other. Any other relationship is allowed as long as they hadn't received prior confidential information about the other side. So I'm getting some questions. I'll get those in a second. But if you have two full brokers, can they be designated opposite of each other? Yes, as long as they don't know something confidential about the other side. You have a provisional broker and a full broker. Can they be designated? Yes, as long as they don't know something. You have a broker in charge and a full broker. Can they be designated? Yes, as long as they don't know something confidential about the other side. So a question comes in, if you have a sales meeting, man, agents like to chit chat. It blows my mind, some of the things I've heard in the office. And they might be talking about their clients' needs to, you know, try to help sell or buy. But once you start sharing price, term, or motive, you cross the line. Yeah, so once you start saying my buyer has to buy because, and this is their price range, da 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 da, you hit that price, term, and motive. So let's say you're at a sales meeting, you're at your firm and you're at a sales meeting, and an agent starts sharing information about their upcoming listing, and then they take it a step further and tell you why the seller has to sell. Guess what? None of us at sales meeting could be designated, because don't we go into that knowing something confidential about the other side? Couldn't the seller's motivation affect their negotiation power? You know, well, they're getting ready to go through a nasty divorce, and I'll tell you, the sooner they can get away from each other, the better. They'll be willing to take anything. Didn't you just learn something confidential about them? Like big time. So none of us can be designated. So careful what you say. That's right. Provisional broker, designated broker in charge can't be designated opposite of each other. Is the BIC required to reassign? So let's say you're in dual, and now we're having the discussion about taking dual a step further. The broker in charge should come to the listing agent and say, do you know something about my buyer that could harm them in this transaction? The broker in charge should be going to the selling agent and saying, do you know something about my seller? And if either party knows something confidential about the other side, then they can't be designated. So maybe the BIC finds another agent. Maybe we just don't do designated. Maybe in the case of the sales meeting where everybody talked and everybody knows, designation is not a possibility in that transaction, because one of you blabbed and we all know too much. So if we know confidential information, we may not be able to do designated in this transaction. If you have received confidential information, your BIC may assign it to another broker that doesn't have that confidential information. The BIC cannot compete with the provisional broker. That's right. That's why they can't be designated opposite each other. Are you asking me if the broker in charge can be involved in sales transactions? It's up to the firm. Some firms allow their BICs to be in sales. Some firms don't. Full broker and a PB can be designated opposite each other as long as they haven't received confidential information about the other side. Do we hear the importance in that? As long as any other relationship, think of a relationship, any other relationship is allowed to be designated as long as they haven't received prior confidential information about the other side. So two non-provisional brokers, that's two full brokers. Can two full brokers be designated opposite of each other? Two full brokers, can they be designated opposite of each other? Yes, as long as they haven't received prior confidential information about the other side. Dual agency is about the firm. Dual agency is about the firm. The firm is representing two clients in the same transaction. Dual agency by the individual, even though you might be a dual agent, you might be working with one or the other, y'all, that still doesn't give you a golden ticket to run around and blab everything that you know if you know anything. We're still going to honor that C in old car, right? We're still not going to tell buyers and sellers stuff. This is the firm sharing information. The broker in charge, I'm going to go back for a second. The broker in charge can be designated with a full broker or somebody that's BIC eligible, as long as they haven't received prior confidential information about the other side. Can the BIC be designated opposite of a full broker? Shake your head, yes or no. Let's see where we are. Can a BIC be designated opposite of a full broker? Yes, as long as they haven't received prior confidential information. Again, you guys, it's up to the firm's policy. Some firms don't let their BICs practice. Some firms say if you do practice, you can't be. We're not going to test you on the firm's policies. We're testing you on what the real estate commission says. What does the real estate commission says? Whew, as long as you've not received prior confidential information. Can other brokers in the office know any information about the transaction after the designation has been made? Once you've been designated, what about the other brokers? Doesn't matter because they're still in dual. So if they knew something before, they may still know something now. So once you've been designated, if you learn something confidential about the other side, you have a duty to share that with your client. Good, fast review of agency. Hopefully we saw the highlights. Hopefully it reiterates the importance of agency. Unit 7 and 8, and again in license law and commission rule. I've mentioned a couple times that unit 7, 8, 9, and 10 are heavily tested units. So I think it's worth me saying again. To have you guys waking up in the middle of the night, yeah, go 7, 8, 9, and 10. I hope so. Because they're that important. All right, so goodness, it's 1 o'clock. So we're going to finish here today. So on Thursday, we're going to finish up license law and commission rule. Please look ahead at those comments if you haven't yet. We need to talk about agent safety. You're not going to be tested on agent safety, but agent safety is one of the most important topics that we talk about. So we'll have a conversation on agent safety. And then we got to go over the rule and expectations. And that's pretty much it. Like I said, we'll talk on Thursday. We need to go back and pick up 18 and 16 like super quick. They'll take us like 45 minutes or an hour to go through it, but we'll do that. I'll talk about how we're going to handle that on Thursday. And that's it, you guys. One more class a week from today. You're going to be taking a test. End of class review. Yes, the end of class review is what is on the end of class exam. So both my end of class exam on the 23rd and it applies to the retake on the 25th. End of class exam review is for our exam. We are not done with license law and commission rule, so we're going to finish that when we come back on Thursday. Wrap it up. It's 1 p.m. Y'all have a great day. Have a good day tomorrow. We'll see you guys 9 a.m. Thursday morning.